Good morning. Good morning. Good morning. Good morning. It's day 28. Day 28. Week 6 of the 3-week, 3-week Alec Murdaugh trial. Day 28. It's March 2nd. Today we start with the defense closing arguments. The prosecution's closing took about 4 hours. I imagine the defense will take 4 to 5 hours. The prosecution will then get to give their rebuttal. I will put up a new poll about whether or not we think we will get done today or whether the jury will get instructed and get the case tomorrow, because we still have 45 minutes of jury instructions at least. So, day 28. I'm going to give you a little bit more info about the jury instructions in South Carolina and what the Rule 404 evidence, the financial crimes, and the rest of it can be used for. Tell you what I think we will hear from the defense in their closing, what they need to focus on. The defense should be focusing on the burden of proof, the connection to family. I think we're going to hear the word butcher a lot to parody their opening. We're going to see Jim Griffin giving the closing. He's connected more with the jury. And I think we're going to see them blaming SLED. This was a rushed investigation. Maggie and Paul deserve justice, but convicting Alec is not that. That's not who did this. And I think he'll use Creighton's words against him, at least I would, where Creighton said, well, husbands have been killing wives forever. Well, is that why you just decided that it was him? Is that the reason? I would absolutely turn that back around on the prosecution. Oh, so this just happens. And so you decided it was Alec. And of course, Alec lied to police when they first arrived because husbands have been killing wives forever. Of course, he thought that he was going to be the person in your sights. He's a lawyer and he doesn't trust SLED because you heard that they put a case on his friend and that friend was acquitted. So, of course, we're nervous about SLED. I think we'll see a lot of that this morning, and I think we'll see a focus on the timeline and how close this timeline really is. So let's get into it. Let me know where you're coming in from, what you're drinking. I have hot water and lemon. You can hear the voice this morning is like, do we give up? Is today the day? Is today the day that we're just done with Emily yelling Creighton? Dick! Creighton! Stop it! One more day? 2 more days? We live here now? Does the jury deliberate into week 7? Yeah, probably. Yeah, they probably do. Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it. I saw the internet saying this a lot. Question, did you see what appears to be a blue shirt hanging in the back window? No, I did not. Not at all. Question, do you think Alec will get a similar order as Brooks, that he can't make any money off of this? Yes, there's a lot of case law about defendants making money off of their crimes. So yes, I do. I don't think that will be too much of an issue in this case, but we'll see. Lauren R. said there are rumors swirling through Waterboro that Alex fired his defense team and will do the closing argument himself. I don't think that's going to happen. It'd be very, very odd if we saw no defense attorneys show up in court this morning. And I hope that we hear at least what the email was about, what the attorneys were in chambers about. If it was an issue with a juror, we'll have to see that juror replaced on the record, and then maybe we'll know a little bit more. Good to see where everybody's coming in from. Let's talk real quick about, I feel like my chair is too high today, but I'll sort that out once the evidence starts. I move it around for news in the evening, and then there's days I feel like there's no headroom today. That's just me being picky. And a YouTuber. Leaper's Fork with peppermint tea. Hello, neighbor. Good to see you. They can't put in items not in evidence. No, they can't. But you know what? They can argue, and they can argue lots of different things. The prosecution argued family annihilator. You know what? There's no evidence of what that is, what that means, what that refers to. It's just words that the prosecutor, I think I probably would have objected if I was the defense. I mean, they asked Alec, are you a family annihilator? And then went no further on it, which was interesting to me as a assumption from Creighton Waters that everybody just knows what he means. Unless he's just using the word annihilator as somebody who destroys people. But I think he meant it. I think he meant it more in a psychological profile way. Question, if not Alex, what would be the motivation of any other shooter to wrap up the hose and move the doggos to different kennels? Why bother with that? I think Alec put the doggos away wrong. I agree, but that's what the defense is going to argue. Who wrapped the hose? I don't know. Somebody Alec hired who worked on the property, who knew the property, and tried to put the dogs away wrong so they weren't running around. I don't know. But again, it's not for us to know. It's for the prosecution to prove. But speaking of what the prosecution has to prove, I thought it might be helpful to go through the 404 jury instruction. This is from 2017. These are modeled after the jury instructions. They don't change much. I imagine it will be the same still. These instructions very, very rarely change. So Rule 404B, evidence of other bad acts. This was, again, last updated in 2014. I doubt it's been updated since, but if the languaging is slightly different, that's why. You are about to hear or have heard evidence that the defendant committed certain acts, which might be similar to the acts charged in the indictment. That's not the case here, but they are going to consider those for other things. You may not consider this evidence in deciding if the defendant committed the acts charged in the indictment. However, you may consider this evidence for other very limited purposes, such as the following. Here's what the jury can use it for. To prove the defendant had a motive or the opportunity to commit the crime charged in the indictment. To prove the defendant had the state of mind or intent necessary to commit the crime in the indictment. To prove the defendant acted according to a plan or preparation. To prove the defendant knew what he was doing. To prove the defendant's identity. So, hold on.
Good morning.
We're going to hear more about motive, crime, and opportunity in the jury instructions.
First off, this morning we have to deal with the issue involving the removal of a juror.
Oh, yep.
A few days ago, I received a complaint from a member of the public indicating that a juror had engaged in improper conversations with parties not associated with the case. I communicated and provided a
That was the
copy
email.
of the communications to the defense counsel. After court, we then met with the juror on the record.
Outside the presence and inquired. Okay.
Juror denied any, denied discussing the case with anyone not on the jury or with anyone on the jury. She provided information that led us to the court to contact the persons that she
Wow.
was suspected of having conversations with concerning the case. Those individuals were interviewed and provided an affidavit regarding the contact that the juror had with them. We then also brought those two individuals in and had a hearing in chambers on the record in the presence of counsel yesterday.
That's what they did yesterday afternoon.
In which both of those individuals waffled on the nature and the extent of the contact.
Because they're in chambers with the court and the
They
attorneys.
also provided a recorded interview, or the state provided a recorded interview with the jurors, and I reviewed that interview last night. So the juror has had contact or discussions concerning the case with at least 3 individuals.
Oh, God.
Though it does not appear that the conversations were that extensive, it did involve the juror offering her opinion regarding evidence received up to that point in the trial that the conversation took place. And in order to preserve the integrity of the process and the interests of both the state and the defense in a fair trial, that juror will be removed and replaced by another juror.
So they're going to be replacing with an alternate. That leaves
I
one
will
alternate
make it
left.
part of the record under seal because of maintaining the confidentiality of the identity of the jurors. I will place under seal the recorded interview, affidavits received, and both discussions with counsel have taken place on the record, and all of that will be made a part of the record. In the case.
We heard rumblings about that.
And we'll bring the juror out to inform her that her services will no longer be needed. We will then replace her with an alternate juror. Any additional comments by the state or the defense? Mr.
Wow.
Not from the state. Your Honor, we do not accept from your ruling.
Yes, sir.
I've sat through everything you sat through, and it's muddled, but we would defer to your judgment. However, I think it's important for me to note for the record.
We defer to your judgment, but we're
The interviews of
arguing.
these 2 people were done by SLED agents, one of whom was named as a witness in this case, and the other who was listed in the notes as being one of the investigating officers. Just to note that, again, SLED has made another bad judgment in this case. I'm not accepting from your ruling.
Yes, sir.
I'm just pointing out that this is just a continuum of a calamity of errors. Thank you.
And the court has not
You good now, Pooh? You
had
feel
any
better?
discussion with any SLED agents concerning this issue.
You feel better now, Pooh?
The inquiry by the court has been directly with the suspected parties involved and with the juror. And this is a matter that this long trial
It happens.
with
It's a big problem, but it
intense
happens.
publicity is certainly,
Yeah.
it would be certainly difficult for any individual to not have some exposure outside of the courtroom to information concerning the case and to also be tempted to engage in discussions
They haven't been able to talk
with others.
about this case for 6
But
weeks.
it is improper, it is contrary to
I don't think he's
my
going to hold the juror in
instruction
contempt. He
to
could.
the jury,
I don't think he will.
daily, multiple times per day. And this juror unfortunately violated that order. So if you will bring out juror number
785.
Yes. And, sir,
Who's he talking to?
he's gone. Let's make sure she brings everything with her.
Because she's
She will,
leaving.
I'm sure. Tony.
Never a slow moment in court. This judge's demeanor, though, remains always
Good morning.
calm.
Yes, ma'am, up here. In your normal spot's fine. If you just
Yeet.
remain standing for me.
Yeah, don't
Good
even sit
morning.
down. You're being excused.
Doing okay today? All right.
He asked you doing okay. I wonder
I
if the juror
have,
was
as you
upset.
know, we've had some discussions with you over the past couple of days concerning indications of conversations with
People told on
few
you.
folks not on the jury concerning the case and expressing some opinion about the case. I have reviewed everything, including statements given by individuals and recorded interviews, and concluded that despite my
Wow.
order to not discuss the case with anyone.
I don't think he'll hold her in
that
contempt for violation of a
intentionally or
court order, but
unintentionally
could.
You've had some discussions with some folks not
Oh, I'd cry.
on the jury.
Oh, yeah. They brought
and,
this juror into court.
Which is going to require me to
You have
remove
to
you
be
from the
heated.
jury. You have been by all accounts, great juror and smiled consistently and have seemingly been attentive to the case and performed well. And I'm sure that with all the time you've invested in it, you probably hate not to continue, or maybe you're ready to go. I don't know. But I certainly want to thank you for your service. I'm not suggesting that you intentionally did anything wrong.
That's why he's not holding
But that
her in
in order
contempt.
to preserve the integrity of the process and in fairness to all the parties involved, we're going to
George.
replace you with one of the
Leave
other
it.
jurors. Have you brought everything that you have?
Can you imagine?
Outside of, you left some stuff in there?
After
What do you
six,
have in there?
after six,
Say it again?
A dozen eggs.
A dozen eggs.
what?
One of the other jurors brought in eggs for everybody from
Oh,
the farm. So
okay.
eggs in my purse and nut water.
All right, well, you're gonna leave the eggs? You wanna leave the eggs or take the eggs?
What
You can
is
take the eggs.
happening?
So, Mr. Bailiff, can you retrieve from
Her
the jury room
things.
her dozen eggs?
She can't go back. Her eggs,
Her purse.
her purse, her
and
water.
glass, and a bottle of water. If you can get those things from the jury room.
That's wild.
As you know,
A
the
juror brought them farm fresh eggs, it seems.
identity of the jurors are
guess.
confidential, not known to the public, and the reason you are still where you are is that cameras are not allowed to videotape the jurors, and we have operated by juror numbers throughout the process, and we'll continue to do so, and your identity will be kept confidential as far as the court is concerned. And we trust that in the event you decide you want to speak publicly about this case, that you wait until after the case is over. You're not encouraged at all to do so, but you have a right to speak to anyone you want.
She can speak to the
if
media.
you decide to do so.
Getting out of this courtroom, she needs to hustle. Marge, the chat is slow. We just have 35,000 people here.
No, I have not spoken with her today, but no, this is not related to, I know we also had some conversation was brought up concerning your ex-husband,
Oh,
but
dear.
that's not a part of this consideration at all. This is totally independent of any other conversation that he might have had concerning you. That's not part of the order of the court.
Gail, we'll talk about that in a minute.
So they're going to get your things, and then
Excuse
once
you.
you're removed from the jury, you can't go back in the jury room.
Yep.
You just
Oh, I
you'll have
guarantee
to
you
tell them goodbye for you.
there are members of the media outside
Okay, all right.
waiting.
Thank you very much. You can go. Thank you.
Whew. That's a whole thing. What did the juror do? Oh, there are going to be media waiting outside to try to talk to this juror. I hope she just walks right by. If you are just tuning in, welcome and good morning. A juror has been removed for talking about the case outside of the jury with third parties. Those third parties wrote into court. It seems that was the
You did a
email.
lot of interesting things, but now a dozen eggs.
Eggs are fucking expensive. They're probably farm fresh eggs
We'll
too.
give them, give her a chance to leave or to take her. She's gone? Yes. Okay, very good. Anything else before the jury comes?
Have we picked an alternate?
Oh, right, absolutely. When they come out, we'll need to select an alternate.
The
and
juror is now
Clerk
free to
has.
speak with the
you
media
have the
if
remaining
they
alternates
want
in a
to.
box. Any objection to the a blind selection of that alternate out of the box?
Nothing from the defense, Your Honor.
They had multiple in-chambers meetings about this. They interviewed people that she spoke to. Poot put on the record that it was SLED that was interviewing those people.
Juror number 254.
Juror number 254 will become part of the
They are down to one
panel,
last
the
alternate.
deliberating panel at this point. 254.
Wow. You are not allowed to speak with the case about anyone, and it seems that this juror has spoken
Mr. Griffin,
Your Honor, before the jury comes in,
and
early in my
expressed
closing
opinion.
argument, we have a blow-up of the photos of Maggie and Paul at the crime scene. I'm going to hold it up
What?
so that the jury could see, the
Why blow it up?
audience cannot see, but I'm just notifying Court TV that please don't display this blow-up during the proceedings.
Blow-ups of the crime scene
Thank you.
thumbs up.
are an interesting choice at this stage
Oh, sure.
for this jury that's been through so much. A very, very interesting choice. So, out of all of the alternates they started with, they are down to one alternate. Most of the jurors have left due to illness. And now there is one who is leaving due to improper juror conduct. The judge did not put a very strongly worded admonition on the record, did not hold this juror in contempt, said that the individuals that were interviewed were waffling. Of course they are, because now they're sitting in chambers. Chambers are not large. They're sitting in chambers with the judge and all the lawyers, and they're like, oh shit, I'm here now. But there had been discussion with third parties, and that is, yes, it's an explosive morning. One of the jurors brought the rest of the jurors fresh eggs, which is exciting. So a juror violated their oath and is being removed. It happened in the Cardi B Tasha K case too. One of the jurors was like, do you believe what? Yeet. Yeet. So all the egg jokes are welcome. I'm going to take a moment to switch browsers because I didn't realize these were in the browser that I don't want. So if you give me one moment, I beg the chat's indulgence. That is why the audio that I don't want is on. So let me beg the chat's indulgence real quick and switch browsers because I prefer Firefox. It doesn't crash my freaking computer. All right, let's get that done so that we have it. Judge Newman's taking a stand break because why not? I need to adjust the height of my chair, Your Honor. So once we start closing, I think that's what I'm gonna need to do because I feel like I'm sitting up too high today. The problems of streaming. So SLED agents. Why were SLED agents brought up by Poot? Because Poot thinks that SLED, one of the SLED agents that spoke to them, I think every SLED agent in this region is probably on the witness list, but the SLED agent that interviewed those that spoke to the jury or spoke to the third parties the juror spoke to are agents that are witnesses in this case. And that was what Poot was taking issue with. Hold on, I need one more.
bring the jury.
They're bringing the jury. I need one more feed up. So they're going to bring the jury. Or the rest of them, I suppose, saying that we do not, they are replacing an alternate. That's a morning that I was not expecting. It happens when cases run this long. You run into issues of jurors who just cannot not, you know? And I get it. How would you feel? Just, I know it's hard. It's like you violated your oath as a juror, but just on the compassionate side, not being able to talk about this case for 6 weeks, how hard would that be to not talk to anyone about it? It would be very, very difficult. So, Aaron Moore said jury friendships are real. I sat on a
Morning.
4-week trial and we are still connected. We
Sir,
meet
thank
up on the
you.
victim's
And good
birthday,
morning one
death
more time.
anniversary every year. I'm
Day
sad that
number
those are the same days,
28.
Aaron, but that's incredible to hear.
Welcome back. Juror number 254. You are now part of the first 12 jurors. We have 13. You're part of the first 12 of the panel at this time.
We're going to be getting into defense closing very soon.
The continuing with closing arguments is the defense's turn. Mr. Griffin.
Thank you, Your Honor.
I know that in the Spector case, the jurors, the Phil Spector jurors get together and do barbecues and stuff.
Good morning.
I'm going to make you look at these crime scene photos a lot, so I'm going to apologize early.
Wow.
I finally get to talk to
We're
you.
at the stage of the case that's called closing arguments. I don't know why they call it argument.
'Cause you
I'm not
argue.
here to have an argument with you in any form or fashion.
You know exactly
What
why they call it an
we're
argument,
here
Jim.
Today, this morning, is to review the evidence with you that you've heard in the courtroom over the last 6 weeks. And in reviewing this evidence, my goal is to address questions that you may have about what you've heard. And
The egg puns in the chat
jury
are
system that we
on
have,
point. They are
frankly,
excellent,
is-
and I love you
It's
guys.
the greatest criminal justice system in the world, because it's the only system, jury system, that a criminal defendant's fate is put in the hands of his or her peers.
Y'all.
In this country, we don't leave the decision of guilt or innocence up to governor, to the attorney general, to the prosecutors, to the presiding judge. You, ladies and gentlemen, make that decision. And as perfect as our jury system is, there's one thing that I wish it provided: an interchange during the course of the trial between us. Y'all sitting there and listening to what we say, and we don't know what questions you have and what you want answered.
And
By
we
the same token,
Do our best to guess.
we may have questions of you that we can't ask. Here's my opportunity to try to answer the questions that I think you have. There may be some things that I go over that you've already decided, and I'm wasting your time, and if I do that, I apologize. I truly do. But I don't, this case is so important, I don't want to leave anything out that one of you may have a question about.
He's going to try to get
I
to all
can
of
probably
it.
speak to for everybody in this courtroom, that there's one thing that we on this side have no question about. It's that y'all have been ideal jurors. We've been here 6 weeks,
Except for the one that was
and
removed.
each of you have come every day on time, and you've been very attentive, and it has not gone unnoticed. And we do appreciate you for your service. We know what a sacrifice it is, being away from your home, your work, your family, your personal obligations. Maybe some of you miss vacations. But you've been here in a 3-week trial, and here we are at the end of 6 weeks. And I want to thank you personally. I want to thank you on behalf of Mr. Harpootlian, Mr. Barber, Ms. Fox, and especially on behalf of Alec Murdaugh. In his opening statement, Mr. Harpootlian explained to you that the law governing your service requires each of you to engage in an unnatural task. In every criminal case,
Sitting in judgment.
jurors are required to begin the process by presuming the defendant innocent. In this case, you were required, under your solemn oath as we began, to presume Alec Murdaugh innocent of these charges. And frankly, as he explained, that's not natural. When you hear on the news that a crime has occurred and an arrest has been made, you feel a little bit relieved. Thank God they caught him. And frankly, I would not be surprised if some amongst you, when you read in the paper that Alec Murdaugh was charged with the murder of wife and son.
They shouldn't have
that you
read in the
thought,
paper. They said
"Oh,
they didn't
good,
know about
they got
this
it."
case.
But those opinions, and each of you, when you filled out your questionnaire, agreed and affirmed that you would leave those at the door of the courthouse.
So
And
he's
that
gonna
you
start
would
with
decide this
presumption of
case
innocence.
solely on the evidence. And that's what the law requires. And when we begin, the law also requires you to presume him innocent of these charges. Now, I've been doing this a long, long time, and up until the advent of instant replay in sports, it's been very difficult to explain just how to do that to jurors, how jurors can do this apply this presumption of innocence. And if
What
you're
does
not
instant replay have to do with it?
interested in sports, I apologize for this analogy, but the analogy is the instant replay. Whether you're a Clemson fan or a Georgia fan, that on a Saturday afternoon, there's a play called on the field, and then it's reviewed. And under the rules, the call on the field stands unless there's visual, incontrovertible evidence that the call on the field was wrong.
I've never heard this
You
analogy
see that
before.
every weekend on sports.
Not a bad analogy.
Here, the call on the field is that Alec Murdaugh is innocent of these charges. That's what the law requires. And that unless and until the state proves his guilt to each one of you individually, voting individually, proves his guilt beyond a reasonable doubt, then that presumption of innocence stays with him. You're not being tasked here to give your opinion.
I'm not
in
mad
this
at the
trial.
analogy.
You're being
I've just
tasked
never heard it
to
before.
apply the Constitution, the bedrock principles that protect us all from a government. And those bedrock principles are, first, you get tried by a jury of your peers. Second, that the jury of your peers begin with presuming you innocent. And third, that you will remain innocent until the government,
Proven.
if they can, proves to you individually, in your mind, that the person is guilty beyond a reasonable doubt. Now,
Yeah, I agree.
the
I think
judge
it's a
will
good
give you
analogy.
jury instructions on
I like
what that means, beyond a reasonable doubt. But the definition has been defined that reasonable doubt is doubt that would cause a reasonable person to hesitate when making an important decision in their personal affairs, such as to buy a house, get married, any consequential decision. And you will be making, when you get this case,
The same amount of certainty as
probably
buying a
later
house.
this afternoon, you'll be making one of the most consequential decisions that you will have ever made in your life, I suspect. I don't know all of your backgrounds, but it will be a very consequential decision. And if the proof that the state has put before you causes you to hesitate, when you go to fill out that vote as you're deliberating
They don't
in your
really fill
jury
it out,
room,
they just kinda-
each of you will have a vote.
Right.
And you will have the right to vote guilty or not guilty. And each of you will write it down. And if there's any reasonable cause for you to hesitate to write guilty, then the law requires you to write not guilty. This burden of proof that we have, many of you may have had experience with civil cases. And in civil cases, the burden of proof is much lower, and it's called by preponderance of the evidence. And you may have seen lawyers or judges or watched on TV as they give a visual image of Lady Justice, who's blind and who's blindfolded, so she does not bias for one side or the other, and there's scales on Lady Justice. And those scales are the scales of justice. And in a civil case, if one party proves their case by a preponderance of the evidence, meaning ever so slightly tilt those scales
I don't know
in
why you're
their
going,
favor, then they're entitled to the verdict. There's another heightened
He
level
has to go
of
again,
burden of proof in a civil case.
he has
called
to go on
by
about the
clear
burden
and
of proof.
convincing evidence.
I said
And
that
the
was
law
the most
requires
important thing they had to
things
cover.
like to prove fraud or some intentional act.
They're gonna cover that the
You have to prove
scales
by
can't be
clear
tipped
and
a little
convincing
bit.
evidence. And that's an intermediate level of proof. And so it's not just tilt the scales ever so slightly in the favor of the party that prevails, but you have to get sort of 3/4 of the way there. But now proof beyond a reasonable doubt is the highest standard of proof the law recognizes. And it is, you have to tilt the scales all the way to one side in order for the state to meet their burden. Now, a little bit about the verdict. You will have an option of guilty or not guilty. My friend Dick Harpootlian over here he travels a lot. He's been to a lot of countries, and he frequently, he recently returned from Scotland, where he attended a
Great.
jury trial in Scotland. And he tells me it's much like this, except the lawyers wear a wig, and I might benefit from something like that. But in Scotland, it runs about the same. until it gets time to the verdict in the criminal case. And the jury in Scotland, where we derive our
Matters
laws
is like,
from,
what?
and
When do we get to go
they
to
are given
Scotland?
3 options. One option is guilty. Second option is not guilty. And the third option is not proven. Not proven.
We talked about that in the chat with our
Now
international
here in
law
America,
nerds.
we have combined the verdict of innocent
No, that's not a
and
verdict.
not proven into one of not guilty.
Interesting.
And so when you go to render your verdict, if it's a verdict of not guilty, it's either you concluded that the defendant is innocent of the charges, or that the government has not met their burden of proof, their heavy
Interesting
burden
way
of
to
proof
explain
beyond a
it.
reasonable doubt. Now, and one of the reasons that
That's an interesting way to
defendants are
explain it.
presumed innocent and the government has such a high burden is because in criminal cases, the defendant really doesn't have the ability, doesn't have the resources, doesn't have the lawful
Sir.
authority to execute search warrants, subpoena documents.
Don't talk to this jury about resources.
To prove his or her innocence. And so a
You can
defendant
subpoena
cannot
documents.
secure a crime scene, cannot lift a crime scene for fingerprints, shoe-wear impressions.
fair.
Cannot secure telephones and get electronic data
Cannot
in the
fix-
course of an investigation.
Cannot fix sleds.
So the defendant is
Shit.
limited on what they can do.
George, what are you doing, sir?
In this case, on June 7th,
My cat is not impressed,
2021,
George.
Alec Murdaugh called 911.
Jim.
And Deputy Green, and then followed by other deputies, rolled up on the scene. And he is standing on his property. His wife and son lie dead in a pool of blood each.
He has
He's
none of
within
it on
yards
him.
of him, and he just put a shotgun down. He had just put a shotgun down.
They're going to use that shotgun to account for the GSR.
And what would that look like? 90 out of 100 cases when the officer rolls up, it would look like the person who had the shotgun and 2 dead bodies may have done it, probably have done it. Certainly is someone who should be strongly considered. And all the officers in this case told you that. Deputy Rutland said, yeah, Alec Murdaugh was a suspect, but there are a lot of suspects out there.
You talked about the
Everybody was a
circle.
suspect. Fair enough. Agent Owen says, well, we have a circle, investigative circle, and it starts with immediate family members, particularly if they found the deceased, the victims. So he's in the circle by virtue of calling 911. And that's fair enough. But what doesn't strike
All
us?
right, we're getting a lot of
as-
white
as
noise on
fair.
this. So I'm going to switch and see.
Fair.
Oh, not any better.
Is that the next morning on June the 8th, after the gruesome murders of Maggie and Paul, this is what is issued, a joint press release,
They've got
Paladin County and SLED, that says, at this time, there's no danger to the public. At this time, there's no danger to the public. We have 2 people who have been executed within, y'all are out there, I don't know, is it 100 yards, 200 yards from Moselle Road? They've been slaughtered.
this sound
At
is
this
way
time,
worse.
There's no danger to the public.
Sorry. Way
Law
worse.
enforcement had decided it had to be Alec Murdaugh.
I can't do that. That audio was awful.
It's a fair question for you to ask yourselves. It's a question that's not been fairly answered in this trial. What we know from June 7th to June 8th, Alec is a suspect and he's in the circle. And from that day forward, he is at the mercy. He is at the mercy of the ability of SLED to exclude him from that circle. They have the ability to do the forensic work, they have the ability to interview witnesses, and they have the ability to gather electronic data. And we believe that we've shown conclusively that SLED failed miserably in investigating this case. And had they done a competent job, that Alec would have been excluded from that circle a year ago, 2 years ago, but he would have been excluded. What did you hear from the witness stand? You heard from Chief Barry McCroy. I didn't know Chief McCroy till I got involved in this case, but his
He's the only person
reputation
Jim didn't know until he got involved in this
is
case.
outstanding, and he's consummate professional. And he explained that when he got there, he was concerned that cars would be pulling up and there were some tire tracks that were not being protected, and that they could have evidentiary value. And then you heard from Mark Ball, who had a conversation with Sheriff Hill, who's another fine public servant here. And he also agreed, we've got to stop cars from coming in here to preserve these tire impressions. And it was not done. It was not done. Captain Chapman from the Colleton County Sheriff's Office, he testified about seeing other sets of tire tracks. As you had came in off Moselle Road, you probably saw where Deputy Green's vehicle had stopped right at the kennels, but then on the other side, where you saw that Alec was parked and pacing on some of these videos, that's where Captain Chapman had talked about seeing tire tracks. And he tried to track them.
Going through all the people.
Sled was coming on, and then it was like a trail to nowhere.
Preserve the tire tracks.
It was a trail to nowhere.
Even yesterday when they went out there, it looked like there were still
Rutland
tons of
talked
tire
about
tracks.
seeing hair
It's a working barn.
hair in Maggie's hands, you'll recall. You didn't hear anything about the hair in Maggie's hands.
No, we
From
didn't.
that moment forward. Was it tested? Was it sent off for analysis? There was no evidence of what, if anything, happened to the hair in Maggie's hands. Was
very
it
fair point.
as a result of a struggle with her assailant? Was it her own hair? I mean, we don't know the answer to that.
Was it Bubba's hair?
We know they failed to take fingerprints from the feed room, and they should have. They failed to properly take footwear impressions from the feed room, or at the apron right outside the feed room. And I think that's. I don't think that's uncontradicted. The Agent Worley, who doing the best she can, did not go there to document footwear impressions. Did not do that. You heard from our expert, Mr. Zerchi, what is required, and I believe Dr. Kinsey also agreed it was not done. I know Mr. Palmbach did, and both. Now I'll get to the shot angles in a little bit, but both Dr. Kinsey and Mr. Palmbach have this murderer for Paul standing on the concrete. Standing on the concrete. Whether 1 foot's in, 1 foot's out, both feet are in, but there should have been footwear impressions. But we'll never know because it was not preserved. It was not taken. The thing that has baffled us, has completely baffled us, is why did they never take DNA samples off of Maggie's clothes, her dress? Why did they never take DNA samples off Paul's clothes?
Probably because their clothes were too
They
soaked
never
in blood,
did.
Jim, but they
They
didn't
never
explain
did.
it.
And we asked their
Well-
investigators, why didn't you? Well, that's somebody else's job. That's somebody else's job.
Well-
It was never done.
Y'all did ask the wrong people
But
all
you
the
know
time
who
to build
who's-
that argument.
Whose clothing they took DNA off of extensively? Alec. And you heard Agent Zapata talk about all the different grids on her shirt where DNA was samples were taken.
They
Was
did.
Alec assaulted on June the 7th? No, he wasn't assaulted. Was Alec wrestling with the assailant on June the 7th? There's no evidence of that. So why are they taking DNA evidence of
I know.
Alec's clothing in June of 2021? Because there's only one
They
reason,
thought he shot them, Jim.
and it goes back to this right here. There was only one reason.
Oh, no,
Only one reason.
that's not a crime scene blow up, court TV.
Is that they had decided.
That's an instruction. This is gonna be hard.
Unless we find somebody else, it's going to be Alec. Unless we find somebody else, it's going to be Alec.
Or they wanted to exclude him. I mean, it goes both ways, include and exclude.
And I'll get into more detail about Maggie's phone. And Maggie's phone was not secured properly. Maggie's phone was.
I now also have hair in my hands.
Let me
Thanks,
just go
George.
right into it. Maggie's phone was found on the side of the road in the morning or early afternoon on June the 8th. Whoever killed her threw that phone on the side of the road, without a doubt.
Without a doubt?
Without a doubt. Alec.
Well, if they think
from the
Alec did
get-go,
it, so you're telling.
has said,
Okay.
you get Maggie's phone, you get my phone, or you get my OnStar data, and you will not see my car traveling down the road with Maggie's phone, because it did not happen. It could not happen. Detective Owen, have you gotten it yet? No, we've not. We sent the black box from on the Chevy to the FBI. It was a new model. Turns out the data's encrypted, and so we haven't got it yet. Well, what about General Motors? I mean, I'll do what I have to do, whatever I can do. And
General Motors told him to fuck
so,
off.
well, you know, we're looking into it. Well, what we learned during this trial is, sure, SLED sent a subpoena via fax machine to somebody in Detroit, I believe, and whoever got it in Detroit, whether there was a number off, I have no idea what the reason was, but we do know the initial response was, we don't have anything. We don't have any OnStar data that you're looking for. There's no indication that SLED followed up with a phone call. There's no indication SLED followed up with a letter. There's no indication SLED did anything other than put it in a file. Put the response in a file. And that was it. That was it, ladies and gentlemen, until somebody watching this trial somewhere contacted somebody at General Motors and said, why don't you guys cooperate with the FBI?
How do you know that's what happened?
SLED on this investigation. And they're like, what are you talking about? So Friday,
What?
sometime in the last 6 weeks, lo and behold, here comes all the OnStar data that you got to see. And that would be great. That would be great. But for the fact that when they seized Maggie's phone, it had, they put it in airplane mode. They knew how to put it in airplane mode. Excuse me, I'm losing my voice. Let me get water. I apologize.
You always take water up with you to the podium, but somebody watching this trial got up on Star's ass. I think somebody that worked there
Something
was
else.
watching the trial,
The,
but okay.
They put it in airplane mode, but what you'll see, I got a photograph, is the location services were still on, meaning still pinging off GPS satellites. And the phones don't hold that much memory. They hold a lot of data, as we have learned, but they don't hold that much memory. And it writes over itself. And for GPS location services,
Right.
the ping points that we see from Paul's phone on all that data, that would have been on Maggie's phone for the 7th. But for the fact that it wasn't extracted until sometime in like June 16th. I think that's the date, but if I'm wrong, I apologize, but it's around the middle of June. And that ping information that we see on Paul's phone, from Maggie's phone, it goes back to like June the 9th. Well, a lot of good that does. A lot of good that does. We don't have it. We would have had it had had they extracted it earlier. Now, Agent Dove says we didn't have an updated, upgraded software that would read it.
This is his
Took us a while
job.
to get it. I don't know why it took him a
His
while
job
to get
is to
it.
explain it from
There's
his
really no
perspective,
explanation
from the
about
defense
that.
perspective. That's
But you
what he's
heard about
supposed to be doing.
Faraday bags.
This is what he's supposed to be
Put it
doing.
in the Faraday bag. So it's not pinging against satellites, not overriding. They didn't do that. And it's lost. Had they done it, I hope we wouldn't be here. I hope, because I know it would say, because we have enough evidence in the record, and we
You
have to
can't
go around our
vouch.
elbow to get to our thumb to get there, but there is sufficient evidence in the record that shows Alec Murdaugh was not driving down the road, Moselle Road, with Maggie's phone in the car and tossed it at whatever time. When he went by at 9:08. I don't know what time they think it's tossed, but that would have gotten him out of the circle.
That wouldn't
I
have
would
gotten
hope,
him out of the circle.
but probably not, because they've been so focused on him. Now, as I mentioned, Alec asked multiple times. I think the testimony was 5 times. Agent Owen.
The evidence
Agent
that would
Owen,
have cleared him is
if
destroyed
you
by
get this
SLED.
data, it will
Or
show
SLED's
it wasn't there.
incompetence
And-
is his argument.
And, we didn't learn
The phone's
why they
not
didn't
the
get it off
smoking
Alec's phone until
gun.
very recently. 'Cause
kennel video
on June,
is-
you'll remember on June 10th, he gave SLED his phone. Yeah, you can copy it. Please copy it. Because it'll show that I wasn't driving, that my phone was not with Maggie's phone at any point in time, going down the road, and that I did what I said I did. Well, they did extract it, but what we've learned, the extraction was a superficial extraction. Not because Alec requested it, that's just what they did.
Well, they were trying to
It's
be
a
deferential.
logical surface extraction. So they didn't go in and pull out any GPS pinging data like you see on Paul's phone. They didn't get off Alec's. Now, if Alec had not made those requests to Owen, and they are disputing that, it's one thing you can be 100% sure of, is they would have called Detective Owen up here on the witness stand during their rebuttal case to say, no, he lied. He didn't ask that of me. I mean, they got Sheriff Smalls in here to say, I didn't give him permission to put a blue light in his car. They came and challenged whether he had authority from the sheriff or maybe a deputy sheriff to put a blue light in his car. But they didn't contradict anything he said about, I've been asking for this data that would get me out of the circle.
Really, Jim?
And now we know why it took so long to get the stuff from his car. It's because it's because the FBI wouldn't go to General Motors on this event data. The FBI was up there and they bought a Suburban, they're riding it around and they're reverse engineering all these systems to try to come up reports. And then they come in here and tell you, well, it's not complete, some is inaccurate, but this is what we got. And during the middle of all that, that's when, lo and behold, we get on start. Thankfully, we did. So then we roll into Labor Day weekend of 2021.
He's very sure that Alec did not have Maggie's
Or
phone
Alex.
in his car. And I
Long-time
just
drug
wonder what he
problem.
knows.
His financial issues, misconduct were
Don't you?
exposed.
Does he know it was
That
dumped?
made him an easy target for SLED. And I hate to say this, but the evidence is crystal clear. From that moment,
Where?
they started fabricating evidence against Alec.
What?
Well, Mr. Griffin, that's an awful charge. Don't all lawyers accuse law enforcement of fabricating evidence? And I can tell you, this guy right here was a federal prosecutor, was a state prosecutor, and some of my best friends are in law enforcement. And I don't make that claim lightly. Here, what you have heard is they came up with a report that says Alec's t-shirt had high-velocity blood spatter on it. High-velocity blood spatter. What's that? That means you're within feet of a shooting, and they didn't just say any shooting. said, in their report, it says,
They've-
as a result
well,
of
they don't know what
Paul's
it
murder,
says.
high-velocity blood spatter on
They
the
don't know
shirt
what it
as
says, because
a
that's
result
not
of
in
Paul's
evidence,
murder.
Jim.
That was number one. Well, let's stick with number one. Why do I say that it's fabricated? Well, you heard Agent Zapata said, we did hemotrace confirmatory blood tests on that shirt. That means there was two types of tests. There's a presumptive test, which is what they use a product called LCV that makes it turn purple where it might be blood. But it turns purple on other agents as well, including bleach, you heard. And you also heard that the shirt came out of the bag wet and it smelled like detergent. Anyway, they spray it, it turns purple in places. So they think, well, that must be blood. Next thing they do at the SLED lab is they do a confirmatory test to see if it's blood.
When?
0 for 74, not blood, not blood. That didn't stop SLED from going out and pursuing with vengeance this report. They didn't give the no blood test result to the guy in Oklahoma. And
They don't know that because
And-
that's not in evidence.
and when it surfaced, they had a problem on their hands. And they were pushing it up until this trial, and you heard the testimony from the stand. That they went from Mr. Bloody Shirt leading up to this trial to Mr. Clean during this trial. And they asked him, and they raised issues during the trial with Blanca, where were his clothes? No one's asking about the man's clothes that he had on the Snapchat video back in, at 7 o'clock with his son until November or so, I think is what she said. I mean, the issue
And they
of
should've.
changing clothes,
Yep, they should have asked.
late to the dance. Because when they went to, as you heard, when they went to the County Grand Jury to get an indictment that you're going to be deliberating on, they told that grand jury they had an expert report that said it was high-velocity blood spatter. And I asked Agent Owen, I said, when you went to the grand jury and when your guy gave you the report, how'd you not know, you chief investigator, how'd you not know that there's this hemotrace test that says it's no blood?
They didn't know.
Well, I didn't,
They should have known. But
I
they
didn't get the email.
He doesn't
I
believe
said it in
that.
somewhat jest, but, did the dog eat his email? I mean, how's the lead investigator in the case not get the lab report that says there's no blood on the shirt? Now, ultimately, it was produced to us, and we were raising Cain about it and saying, how can you say this on one hand and that on the other hand? And here we are with a Mr. Clean theory, that he washed off after brutally murdering Maggie and Paul.
Surprised they didn't.
He
object
takes a
about the
hose and
blood
washes
spatter.
himself off and gets in a golf cart, butt naked, I guess, and drives to the house. So that's the blood spatter fabrication.
Surprised they didn't object about that.
The other is,
But they didn't.
is this blue raincoat with GSR. And do you remember that testimony? Shelley Smith, who worked for Ms. Libby and Mr. Randolph,
Don't come for Shelley
had
Smith. The
told
jury's not going to
SLED
like that.
after September, after Alec problems had been exposed, after she had a conversation with a Allendale police officer following an accident investigation in which she was in an accident, that on the morning, she said in here, as she told you, on Wednesday after Mr. Randolph's funeral, and that turns out to be, I think, June 16th, that Alec shows up at the house at Alameda at like 6:30 in the morning, knocking, trying to get in, and he has a blue tarp. And in this blue tarp, she lets him in. He goes upstairs with this blue tarp. He comes back downstairs. He lays this blue tarp out on Ms. Libby's retirement rocking chair in the living room, and then he leaves. And then she leaves to go to her day job. And when she left, the blue tarp was laying out on Ms. Libby's rocking chair.
Thank you for the super
That was her
chat, Jessica.
testimony. And so SLED gets that, gets a search warrant, goes to Alameda, and they seize a blue rain jacket. They seize a blue rain jacket. And when they do, they take that blue rain jacket and they show it to just about every family member.
The photo of the family seems to be what's up on the screen for the defense right now.
That they can think of, and it's defendant's 87, Doug, if you can pull it up. But they show this blue rain jacket to as many family members as they can get in contact with, and the rain
Who's
jacket
more
is,
fiery?
and no one recognizes it. No one sees it. No one said Alex ever worn it. No one said Paul's ever worn it. No one said Buster's ever worn it. No one said Maggie's ever worn it. Have not seen this blue rain jacket. Has not seen this blue rain jacket. One more thing about this blue rain jacket. When they did the search at Alameda, John Marvin was there. And John Marvin asked him, did you find anything? And they said, well, we found a blue rain jacket back on the property.
Oh, I'll get to that at a
Back
break.
on the property. Back on the property. And he said, well, my dad drives a buggy around, and maybe it fell off the back of his buggy. Clearly, John Marvin was understanding that it was back on the property, and then they asked him to come look at the blue rain jacket, and he was told it was found in the closet. He was told it was found in the closet. And he said, that didn't sound right, and they never clarified it. Now here's a picture, I'm not even gonna put it up, but I'm
I'll
gonna,
get back to
411 is a picture of this closet, and you can see
He's the former AG.
the blue rain jacket that's just sort of folded up and stuffed down here at the bottom right. That's the blue rain jacket. And apparently right before this trial, they showed Shelley Smith this picture and says, does that look like the blue tarp you saw? She goes, well, yeah, sure, it looks like it. They never showed her this. They never showed her this.
Because she said he
And
carried
she
it
said-
in bundled up.
This, when I'm saying this, is, I think it's 87, it's on the screen. She'd never seen that. Never seen this. But they did GSR testing on this and it says, whoo, it's hot. A lot of GSR on that. A lot of GSR on that. Manufactured evidence, ladies and gentlemen. And then,
It's fair because the prosecution's theme
And
is
then
manufactured alibi. It's
there's
very
this
fair the
issue of
defense is turning
misrepresenting
it to
what are the-
manufactured evidence.
type ammunition found in the shotguns at the residence at Moselle. Paul was murdered with first shot was a buckshot. Went to his chest, he was turned this way, went in here, and then out under his arm. And that
Trixie
was
Red, I
buckshot.
wish we could watch this closing
The second
2X as
shot
well.
was into the head, either, depending on what expert and what pathologist, it's either this way or this way, but into the head. And that was still duck shot. I learned that you can't shoot ducks with anything but steel pellets because they don't want lead in the water. So you got to have steel pellets. And then Agent Owen testified, admitted begrudgingly that he had testified to the grand jury that
Hello,
there were
Jenny.
4 weapons found up on the
Enjoy
property
teaching.
in the gun room, 12 gauges that were loaded, or I'm not saying 12 gauges, I'm sorry, 4 shotguns that were loaded with buckshot and birdshot. There's 4 other ones. So
Thought on that.
that matches. Well, guess what? Totally not true. That was totally not true. And he admitted on the stand it was not true. He admitted telling Alec during the interview, and he said, well, I can do trickery. And we're going to see that shortly. But and then I said, well, you're trying to trick the grand jury. No, I didn't say that. Well, we walked through it, and he did say it. And he didn't remember it, and you'll remember the testimony. And I said, well, people make mistakes, don't you? Yeah, that was a mistake. And it's okay to make mistakes, right? Yeah. And you can make mistakes about time. Well, that's the most common thing people make mistakes about. It's not all right for Alec Murdaugh, who's in the center of the circle, who's not all right for him to make mistakes about time. It is not all right, according to the same investigator who says it's okay, happens all the time. But here we go, and then Eureka. They finally get into Paul's phone in April of 2022, and they see Alec. Well, they don't see Alec. They see Cash the dog, and they see Paul's feet walking around.
And they hear
and they
Alec.
hear voices in the background. One of them sounds like Alec. And off they go. They go off and get an indictment from the Colleton County Grand Jury, relying upon high-velocity blood spatter, relying upon 4 guns having the same load, and relying upon a rain jacket that's got GSR on it, and Alex lying about being down at the kennels. Now we know, after we've been here 6 weeks, of those 4 things,
Bixby voice privacy contacts have been updated. To continue, review the updated items on your screen.
I'm so sorry.
What?
No, that was turned on.
The tech is not having it. Remember during the closing argument for Roddenborn that the Amber Alert went off and all the phones started going off? Same.
But what we know is 3 out of those 4 things that was presented to the Colleton County Grand Jury that you're going to be deliberating on.
My kid's personal Uber driver, speedy
recovery.
recovery, and I hope this
Aren't
surgery goes
true.
well.
No blood spatter, no GSR rain jacket that's ever been connected to Alex whatsoever, and there's no loaded gun. So we're left with the lie. We are left with the lie. Now, Alex lied about being down at the kennels in Alameda. And why did he lie? And that is certainly a fair question. And that's, and frankly, I probably wouldn't be sitting over there right now. He had not lied. But he did lie. And he told you he lied.
Huh.
And he told you why he lied. He said he lied because, I'll tell you, he lied because that's what addicts do. Addicts lie.
Wouldn't be
He
sitting over
lied
there
because
if
he
he
had a
hadn't
closet
lied.
full of skeletons, that he didn't want any more scrutiny on him, which is the most ironic thing in the world because depending on which day of the week, their theory is that he slaughtered his wife and son to distract from a impending financial investigation. But he puts himself in the middle of a murder investigation, and he puts himself in the spotlight of a media firestorm. That's their motive evidence, and we'll get to that. But he lied. He lied because of his drug paranoia kicked in, and he was clearly in the throes of addiction.
I wonder if he's going to point all the SLED agents in the
He lied
audience.
for all those reasons.
He lied because he
But
doesn't
what he
trust
didn't
all the
lie-
beards.
What he didn't lie for is because he was covering up the fact that he killed Maggie and Paul. That is not the reason he did it. Doug, will you play the dog kennel video, please? I'm going to play the dog kennel video.
He didn't lie because he killed Maggie and Paul.
There's a chicken. Catch. Quick.
That dog's tail is just as happy as can be.
4 minutes later, the state would have you to believe that Alec Murdaugh up and blew his son's brains out of his head
Okay.
and murders his wife. after having that conversation about Bubba having a chicken or a guinea. 4 minutes later, their case wants you to believe that this is a family down at the dog kennels doing what families do. They're checking on a dog, tail, Bubba's out running around.
Everything's
And
normal.
they're saying, Bubba, got a chicken. Now, why would Alec not want law enforcement to hear that? I mean, there's nothing on that tape. There's nothing on that tape that indicates there's any strife, any conflict, any anger, any planning, anybody being afraid, anybody running, anybody scurrying. Nothing.
Well, it's not a video of murders, Jim.
Maggie, Paul, and Alec down at the kennel. That's it.
Well, why would he lie about it
And
if
their
he didn't know
timeline-
when they were killed, Jim?
It's based on the fact that this automated
wanna
thing
be in
kind of
the
messed
circle.
me up, but the point I was going to open this up and say, you know, under their theory, if your phone's not moving for some period of time, you're dead right then. You could be run over in the traffic 2 hours later, but if you're not answering a text 2 minutes after you receive it, you're dead at that point. And that's their case. That is their case on time of death. Is phone stop moving, you're dead.
The thing is, though, Jim, we know that they're dead. And we know that they're dead in that timeline before
You've
he gets
heard
back.
testimony from a lot of witnesses.
Oh.
I would say practically every witness who took the stand, who actually knew Alec and
I don't know
Maggie
if
and Paul
I'm
and
convinced by
Buster,
that.
testified under oath how much Alec adored Maggie. She was his all. Some people describe Paul as Alec's best friend. His relationship with him was awesome.
And yes, I saw all of
And,
your comments that said it wasn't just one
that was
person that
unanimous.
wasn't using their phone, it was two at the
And
same
then, so I
time.
want to just play briefly a clip from Blanca testimony about Alec's relationship with Maggie.
You've also, I think, in multiple interviews with Sweat and others,
What?
described, I think the words were,
What? You're not allowed to
Meg-
replay video. You can there was an objection. You can use transcripts, but you can't play clips of witness testimony from YouTube. I have never. Wait, is Metters doing the rebuttal? I thought that the state wasn't allowed to split their attorneys. You can't use video, and in depth be heard when they tried. It was absolutely shut down.
Please continue, Doug.
Oh, all right. Well, I guess that's what we're doing now.
Isn't that what you told Sweat?
Didn't clear it beforehand.
What does that mean, Maggie was his all?
He adored her. He loved her. He adored her.
Worshipped her. I mean, just treated her as somebody he adored, correct?
Exactly, yes, sir.
Wow.
Now, this was her testimony from the witness stand. And then in every trial, there's
You use the.
you hope
Okay.
you find
You use
know,
the transcript.
some very authentic witness,
Or you ask.
part of the
defense is like,
fabric
"Fuck
of
it, we're just
America that
doing
comes in this
whatever."
courtroom. And we had it in this case, and it's Dale Davis. And I want you to remember what Dale testified about Alec's relationship with
God help us that Metters is doing
his
the
family.
rebuttal.
We played Dale Davis's.
Me?
Oh,
When you
God.
use the phrase lovey-dovey about Alec and Maggie, what does that mean?
Means they loved each other.
What, in your presence, you described them as being lovey-dovey, didn't you?
Yes.
I am
And tell the jury what you meant by
surprised. I shouldn't be at this point.
Every time I always say them, I've never seen that man even raise his voice at his wife or kids. So or his wife. I've never seen him even, none of them argue.
Not yelling doesn't mean things are
But he
okay.
always, anything she wanted or the boys wanted, he would try to get it.
And how would
Anything
you-
they wanted. That
what
goes
was
to the
your
financial pressure,
observation about
doesn't
the
it?
relationship with Paul?
Doesn't that go both ways?
They like to hunt and fish together. I mean, they drink beer
Anything
together.
they wanted, he tried to get it.
Um,
Okay.
That was Dale Davis. Which brings us to the question, why? Why would Alec Murdaugh on June 7th execute his son Paul and his wife Maggie,
The
who
lady
he
in black, the
adored and
state
loved?
cannot appeal.
Why? The
They did
state's
not-
theory is that
The
he ha-
state did
that
not use video.
it was a storm a-coming. Clouds are arising.
They used
And that
video
his
of his
Financial house of
Police
cards is about
interviews.
to collapse.
Those
He's
are
about to be
evidence.
exposed. And
The videos from YouTube of witness testimony aren't evidence. The transcripts of that testimony are evidence, and the testimony itself is evidence. Alec's police interviews are in evidence. The tape of those interviews is in evidence. The disc of that is in evidence. That's the difference between using the YouTube replay instead of the transcripts.
because of that, he does what every rational person would do. Go kill your wife and son.
Murder's
That
not
is their
rational.
theory of motive. That is their theory of motive.
It is
That-
not a great theory.
And it worked too, by the way. Because
What?
he killed his wife and son. Guess what? Jeannie Seconder quit asking questions for a few weeks.
I
In the
like-
voting case, that won't be worth anything now that his wife and son's been murdered because he's sympathetic. Have you heard such? One thing Mr. Waters and I agree on is the best thing about jurors is you bring your common sense in here and you use your common sense. And that's what it's all about. That's what your collective wisdom. And just collectively think, individually think, what kind of sense does that make? Alex, his financial house is a wreck. He's stealing money from clients. He's got to produce a financial statement, maybe, in a hearing coming up. And his dad goes back in the hospital that day. His dad goes back in the hospital that day, and he ultimately dies a few days later. Okay, so I get a call. Jeannie comes in. My dad's going to the hospital. Paul's coming home. That'd be a good time to kill Paul, wouldn't it? That is their theory of the case. And if you don't accept that, beyond a reasonable doubt, ladies and gentlemen, I submit the verdict has to be not guilty.
Are you done?
Because there's no reason for him to do it. No reason whatsoever.
Huh.
Now, you've heard a lot of testimony about these financial crimes, misdeeds, and he told you he did it. He told you he did it to support a very expensive drug habit, and none of that's an excuse, but he is an addict, and addiction is real.
And he'll be
And addicts
punished for
lie,
those crimes.
addicts cheat, addicts steal,
He'll be
keep-
punished for those.
getting their drug.
They would do anything to keep getting their drug. I don't know if the
The
direction the
evidence was
defense wants to
permitted
go.
in this case for you to hear solely to consider, did he murder his wife and son because he had this storm a-coming, that he was going to be exposed? Is that why he murdered? That's what they say. That's why he murdered, and that's why you're allowed to consider it. Now, Judge Newman in his jury instructions will tell you that's all you can consider it for. You can't consider it by saying, man, I never knew he could do that. So if he could do that, he must be able to do the most heinous crimes in the world.
That's
Kill his
the-
wife and son, execute him style. I mean, that's a no use of that evidence.
That's
The only permissible
propensity.
use of the evidence is
No use.
that sufficient provocation, motive for him to kill his wife and son? Is it sufficient motive, not provocation? And And the evidence in the case is that there was no impending financial doom on June 7th. June 7th was a day which frankly was no different than any other day in the frenetic lifestyle of Alec Murdaugh. He
No
had so
different?
many balls in the air. And he even, I forgot his paralegal's name, and I apologize to her. I think Christy.
Annette?
She said he would come in like a Tasmanian devil.
Annette.
I mean, he was frenetic. And they were on to this
Oh my goodness, I am so tired.
$792,000 fee in the Ferris case. And they were asking questions at Chris Wilson's office. But the reason they weren't concerned that he was stealing money. They were concerned that he was sheltering money, trying to hide it from the being disclosed in the
That's
voting
true.
litigation, in which he was a defendant. And they didn't want any part of that.
That's what Gene
And-
said.
And that situation with the with the Ferris fee, as Ms. Seckinger, Jeannie Seckinger said, that was a one-off. That was completely on its own, different type conduct than all the other stuff that you heard about. That was a one-off. And what happened on June 7th? She says, I'm in his office, and he gets a phone call.
I might play this
His dad's
closing
put back in
again
the hospital.
later to take a nappy nap.
She thinks that he told her it was terminal. He may have, I don't know, but his dad is put back in the hospital. He wasn't terminal that day, but the next day he got the terminal diagnosis. In any event, she takes off her CFO hat and puts on her mama bear hat and hugs him and a friend hat and their theory is he slaughters Maggie and Paul to buy time from her investigation. That is it. That is their theory. That is their theory. And it's totally fabricated. They've got no evidence of that. There's no evidence that Maggie was on to his financial misdeeds. There's no evidence that she was about to blow the whistle on him. There's no evidence that that he had a $20 million life insurance policy on her, and that if he murdered her, that he could get out of financial bind. None of that. None of that. And I asked Ms. Secretary, how long of a delay did that buy Alec? Well, month maybe? A month? A month? That's their theory. That's what their case is built upon. And then this motions hearing is, there's a motions hearing scheduled for Thursday. It had previously been scheduled 2 other times. And it was continued at the last minute on the other occasions because 2 of the lawyers had cancer and were receiving treatments. But it wasn't sure it was going to be continued previously. Did he go murder anybody, to get out from under those prior hearings? No. This had nothing to do with it.
Which is a fair argument.
So they brought the plaintiff's lawyer in. He's an
That
excellent
doesn't make
lawyer. And
sense.
he's, like any plaintiff's lawyer. I'm going to clean his clock. I'm going to take everything he's got. That's what they all say. So then we had to bring the defense lawyer in to say, that was a negligent parenting case, and it wasn't worth the paper it was written on. I mean, folks, that's what we are in a murder case, and that's what we're having to deal with because that is their theory of motive. But even if the financial day of reckoning was impending, if it was right there,
Does it make sense that he kills his wife and son as a
Alec
result?
would not have killed the people he loved the most in the world. There's no evidence that he would do that.
Would not have?
We do have evidence of what he would do and did do. And if you'll pull up Defense Exhibit 125, which is in evidence.
Would not have or didn't?
On September 2nd, 3rd, 4th, I forget the date. This is the Labor Day weekend. He gets his drug dealer, Curtis Eddie Smith, to shoot him in the head
That's not in evidence.
because he couldn't go on. Because
Oh,
it
no,
was
it is
all
in
going to come
evidence.
crashing down. And he
Withdrawn.
had a big life
That
insurance
is in
policy.
evidence.
So when Alex is at financial collapse, he doesn't go kill somebody else. He tries to end it himself. This is a natural response. You don't want anybody to do it. But this, people kill themselves from being exposed. Kill their
No, Jim, people do kill their
wife, their
families
daughter,
when they get
son,
exposed.
the apple of his eye.
Yeah,
as some
no,
people have
they-
said.
They do that, though.
That's not. That is,
That's not what.
I don't have the adjective for that. That is so outlandish. I don't have a word for it. Totally illogical, irrational, and insane. Those are the words I wrote down. For someone to kill their loved ones when their criminal conduct is being exposed. So, you can take that down. Yeah, thank you, Doug. Yesterday we heard a lot from Mr. Waters. And I've been in Mr. Waters' position. As I explained, I was a federal prosecutor for a number of years.
Okay.
I've been a state prosecutor, part-time mostly. And I've done his job. It's a very rewarding job. And I hold him and I hold his office in very high esteem. But there are just sometimes folks just get caught up in a case, they get a desire to win, they get so intoxicated by the attention that's brought on by the case that they start sort of a win-at-all-cost approach. And I'm going to go through some things that Mr. Waters stated to you that just aren't facts and aren't supported by the facts and the evidence that you heard. And before I do that, I want to give you a cautionary statement. We lawyers aren't witnesses. I didn't take an oath to stand up
prosecution
here
is intoxicated
and talk to you.
by the attention of
I
the
have
case.
ethical obligations about what I can say and limitations under
Okay.
the rules, but I'm not a witness. I'm here to talk to you about the evidence. And the same applies to Mr. Waters. You decide what the evidence is. You decide. And
Further, we're going to take a short break
Oh, thank God.
for about 10 minutes.
I need a
Please do
break.
not discuss the case.
Are the attorneys texting each other? It looked like the attorneys were texting each other back and forth. I don't know how y'all are feeling about this closing so far. The points that I thought that Jim would make, reasonable doubt, burden of proof, presumption of innocence, he made at the beginning, but then wandered. Let's talk about the few things that stick out in my mind, because his approach is a little hard for me. And look, it's a murder trial. It is not supposed to be the most riveting thing necessarily, but it has to hold the jury's attention. We've heard multiple news reports that a juror fell asleep during closing yesterday. So it has to hold the jury's attention. He talked about the grand jury, and I'm glad that he did. He talked about the fact that people can make mistakes, and he wanted to get into the blood spatter shirt that was presented. What I'm still not clear on with regard to the grand jury, and I think why we're not hearing more about it, is because I don't think that confirmatory test, I don't know when the confirmatory test came in, but the investigating officer didn't have the confirmatory test when they went to the grand jury. That should be looked at. How that happened should absolutely be looked at. I don't know if it's going to sit with the jury. I think the misstatements with regard to the birdshot buckshot make more sense that they would come up as a problem with the grand jury. That he was saying they were mixed loads, birdshot buckshot, instead of saying they were mixed in that they were loaded with two different brands of shot, which seems to be what the case was. And so I think there's a lot more that needs to be done looking into what's going on with the grand jury. But does this jury care about that? I don't know. I don't know how much this jury cares about that. But I think they could have used that to tie up more strongly the, fabricated, manufactured part of the case. They're manufacturing this alibi out of nowhere. And there's room to run with that because the prosecution's running with manufactured alibi. It's like, you want to talk about who's manufacturing something? Let's look at the state. And they should be talking about it. I'm perplexed that they're just playing video off of YouTube of testimony. I realize why logically it seems like, well, that's what the jury heard. They didn't seem to run it by the court or counsel. We've seen other cases where it's not allowed. It's not in evidence. The testimony's in evidence, but those videos aren't. So I think at least it should have been dealt with prior to the closing. They didn't. Okay. The court didn't care. So I guess neither do we. What else? He talked about the financial crimes and use of propensity. I think he could have gone into use of propensity more. And he talked about the kennel video and the lie at the kennel and why lie. And he talked about, Alex said he lied and he told y'all that he lied. And he didn't go into the fact that there would have been trauma after seeing that, which I'm surprised by, and say, he told you he lied, but at what point? And so Priya, no, they pulled the clips off of YouTube though. That's the only where they pulled them off of YouTube and saved them and then played them back through VLC. But those are YouTube clips. That's the only place you can grab the trial. So that's where we're at. I'm going to answer some questions. I'm surprised the prosecution didn't object to the way the high velocity blood spatter shirt was discussed in closing, because that witness was never introduced. And there was very little in evidence about that. Alec talked about it on the stand, about the fact that there was a report, and maybe one or two other witnesses mentioned that there was a report when the defense asked, and they said they hadn't seen a report. So that's where we're at on that. Let's answer some questions. It's an interesting thing, but I think the clips of the testimony, and again, they could have read the transcript of the testimony. The transcript is what stands. It doesn't really matter in the end. I'm just surprised to see it, and surprised they didn't clear it with the court. They probably didn't even think to. Jim seems tired. We're all tired. That's fair. But when he was playing the groundskeeper saying anything Maggie and the boys wanted, anything they wanted, Alec would try to get it. He was coming to the end of being able to get it, wasn't he? And so if I'm doing the rebuttal in this case, I'm taking, you heard that testimony. Anything they wanted, he tried to get it, and that was coming to an end. Because the prosecution's now leaning into shame. I think means and opportunities, their stronger argument. We'll see. It looks like Metters is doing the rebuttal. Lord help us all. All right, let's get to some super chats and answer some questions as we go. So we're going with the in and out. Wasn't John List the man who killed his family for shameful financial stuff? I don't know. I don't follow a lot of true crime. I know that might seem shocking. I don't follow a lot of true crime, and I don't cover a ton of cases, criminal cases. We cover some criminal cases. I cover a lot of civil cases on this channel. So I don't know. The chat will probably know. Where's all the stolen money? We don't know. Where'd the money go? I don't know. He was the only financial support for his family. Yes, he was. And they should absolutely get into that. Can the juror get in trouble legally for this? Betty C. For those of you just joining, hi, there's almost 50,000 of you here. Do the YouTube things. I appreciate it. Can the juror get in trouble legally? If you did not join us bright and early this morning, absolutely no shade. I wish I hadn't either. I'm very, very tired. I love being here with y'all, and interesting stuff happens in the morning, but also tired. So this morning, a juror was removed for having conversations about this case, not with other jurors, but with third parties. The court made a very thorough record about how they investigated that, who they spoke to about that, but a juror had been talking about the case and the juror was removed. Could the juror get into trouble? Yes. That is contempt of a court order. Did the juror get in trouble? No. And I thought the court was actually very kind and compassionate when letting the juror go. I worked for some judges that would have eviscerated a juror for that, but they were also dicks to jurors during the voir dire process. This judge has a tremendous amount of respect for jurors. He has always been very clear of their time. He's been very complimentary of them. He's always said, thank you for your time. You've done this, you've done that. So He didn't. He could have. But it also depends, lawyer, depends, on what they heard in their interviews. The judge did say there was some waffling about how much discussion, but the juror expressed some opinions with regard to evidence that had been presented or whatnot. Obviously, it didn't cut to the point where the judge thought it was sanctionable. Poot objected to it, saying, SLED interviewed these third-party witnesses that heard from the juror, and threw it back on this as, again, Poot never misses an opportunity in front of the cameras to take a dig at SLED. So that's the sense I got. No Bubba slander. Question, what collagen powder do you use in your coffee? I've never heard of that. I put a bunch of stuff in my coffee. Collagen is one of the things. Also, yay for the end of this trial. Your girl is tired. Yeah, same. What collagen do we use? I would have to go find it because it's in a blue container and it's not coming to the top of my head because we decant it. Vital Proteins, I think is the name, but A, you can get it at Costco. B, blue container. C, really like it. Mixes well into liquids. Question, I just watched Blanca's testimony and the prosecution didn't use any of it in closing. Strategy or idiocy? They talked about Blanca's testimony in closing. Creighton Waters talked about Blanca and the shirt. It was in their PowerPoint, and he discussed the change of shirt and the fact that Blanca felt like she was asked to change her story. So they did talk about that. They didn't touch on folded clothes and the shower and the rest of it. Will the jury convene over the weekend too? I don't know. We will see what this court does. Lisa with a law dog said News Nation is saying an alternate was asleep. The same lady with Kleenex in her ears. It seems like that might be the last alternate because from what we heard in court today, the alternate that replaced the juror is a male alternate. Jessica Lambert, is Jim the right person to do the closing with him being Alex's best friend? I think there was a strategy to it. I think it will feel like it comes from the heart. I wonder if some of you feel like it's coming from the heart or if it's kind of rambling, or if this is very hard for Jim to do because he's so close to Alec and the family. He knows these victims personally. I think it's got to be very hard for Jim. And clearly, we've got some pollen and allergy things going on, which is not Jim's fault at all. But this is clearly clearly difficult for Jim. But does it resonate with the jury? Does it feel like he's just having a chat with them? And that's going to depend on the juror. And I will ask you guys later if you like his style of closing. Not necessarily what he's saying, not do you agree with what he's saying or not, but does his style, where he's just much more conversational, does that resonate with you? It might be nice not to have people yelling and pounding on things. Laura Lou, can the defense use that he's already going to spend the rest of his life in jail for financial crimes? So why would he not admit to this too? They haven't done that. And we haven't seen them say, look, he's admitted to the things that he's done. He's not admitting to anything that he hasn't done. What we've seen is them getting really close to saying he'll be punished for that. They're saying he's already done this and this and that. I thought they would say, and he's admitted to this. That's taken care of. You don't have to worry about it. Ali Julie, can you say hi to my granddaughter, Thea? Hi, Thea. She's obsessed with you and the pickle. We didn't even pickle yesterday. Hold on. We did not pickle. Now that my cats are out of the room, I can pickle with impunity. Oh, I hit my keyboard. Apologies. Jill Pill, on a scale of 1 to 10, how bad is this? With the juror, I think it's kind of appalling. But also, I get it. It's a hard thing to do. And for that juror, they've got to be horrified that they are now excluded. They're going to deliberation this afternoon or tomorrow. They've sat through 6 weeks out of work of trial, and they are not going to get to discuss this with their fellow jurors that they've gotten to know over the last 6 weeks. They have got to be gutted by that. But they were in control of their own actions. And what you can't do is talk about the case. The court says every single time, you can't talk about the case. So you can't talk about the case. Renee, I sent you 2 links of IG animated reconstruction based on testimony. Nobody made it for the jury. So that's why they didn't see it. I will take a look. My DMs have been busy. That's why I always say my public email is the best way. And if you just want me to email you, if you don't want to email me, that's fine. LawNerdAlert.com. Join the thousands of law nerds, tens of thousands of law nerds at this point, to get my alerts. Because if you want to stay in the loop when we go on Verdict Watch, unfortunately, Text Crew only works in North America. And we are working on a better solution. But until we do, email will be the way I keep you posted. So LawNerdAlert.com will get you there. Amy Lynn, can't they say how the AG came in the courtroom? They could talk about it. I don't know if they could argue the AG came in to intimidate. I don't know if that's in the evidence. Maybe I didn't hear who came in. Well deserved. Thank you. Do the replacement jurors, the alternates sit in the jury box with the jurors. Normally it's a row in front. And I think we've seen this jury box is fairly long. So they will arrange them. But yes, the alternates are there through everything. They go to the jury view and all the rest of it.
You may bring them in.
Bring them in. I wonder if she thought she could talk about it as long as she didn't say she was a juror. What was thought is not, what was thought isn't really going to be the thing, but she would have clearly spoken to it with the court. I'm not mad. I'm disappointed. That was definitely the judge's vibe. Aren't people in the courtroom? Her identity is exposed. Gail, her identifying information, name, address, phone number, those things aren't. But yes, this juror has been going by juror number, but their face is still in the courtroom. But the jurors' faces have been in the courtroom every single day. Emily Hughes. Hi, Emily. Hi, Emily. It's my birthday. Don't you didn't think we'd be here to spend it with you? Mr. Waters did a great job with the timeline. Drinking coffee in Central Illinois. Hello, hello, hello. Coming in hot today. Today came in spicy. My secondhand embarrassment for her is real. She must have been mortified. Motion to adopt Judge Newman as our collective law nerd grandpa. Lawpaw. I'm here for it. I like Judge Newman quite a lot. Obviously, Poot thinks the juror was an NG. The juror might have said that in the conversations they had. It doesn't sound like he actually believes everything he's saying, Rebecca said regarding Jim.
Yesterday in Mr. Waters' closing argument, he said that the evidence established that Paul and Maggie were murdered with family guns.
A different tone.
I mean, that perhaps is his view of the evidence, but that's not a fact. In fact, the state's ballistic expert testified
I'm glad he's talking
that
about
the 12-gauge shot shells, as you found in the feed room, were fired by the same shotgun.
Because the defense does not agree.
The shot shells, the things that rolled under the door, were fired by the same gun. That's all he testified to as the shotgun. Now, they have put a lot of guns in evidence here that have nothing to do with the crime. So we don't know what shotgun was used. It could have been a shotgun bought at Walmart that afternoon. It could have been a 20-year-old shotgun. But all the evidence, ballistic evidence, is shot shells were fired by the same gun. And that's, don't know that you really need an expert for that, but that's what the testimony was on the shotgun. With regard to the 300 blackout, you'll recall that this guy, Paul Greer, testified that the cartridges found at the crime scene, and Maggie was shot with a 300 blackout, that the tool marks, it's called tool marks, that the extractor and ejector marks from the cartridges found at the crime scene matched extractor and ejector tool marks on some cartridges found at the house and some found at the shooting range. And
if he doesn't do a good job with explaining this, Runkle and Rob will eviscerate him.
That is one of the most reliable indications. It did not match. No match. And he also did not compare projectiles. There was a projectile found. When I say projectile, that's the bullet. That's the bullet thing. That went into Maggie's body and and broke up, but one went into the dog house and was found in the dog bed. And so they have that. And what they did not do is take that projectile and dig projectiles out of the berm where the shooting range was and compare it to see if they match. And that's the most reliable way to do it. Now, you know, in David Owen's notes, he said that the ballistic expert can't be 100% sure until you have the gun. And you heard, you know, my cross-examination of Agent Greer, and this tool mark ballistic examination is somewhat soft science. It's come under criticism. It's what they rely upon. Not every investigative lab relies upon it. That's what they did here, but it's not gospel. It's not gospel. Another thing about the 300 blackout, he in his closing, Mr. Waters repeatedly said that Alec bought it, and I assume we're talking about the replacement. I don't know.
Maggie paid for
Alec
it.
bought it. Well, Alec didn't buy it. The evidence in the record is Maggie bought it.
Well,
And he
Maggie
kept saying
paid for
it's
it.
the defendants, and it's not the defendants. The replacement 300 blackout, which frankly no one had seen Paul with it in quite some time except Will Loving on one occasion in sometime in March. It was Paul's gun. It wasn't Alec's gun. Paul's gun.
I think we need to go back to the science on tool marking.
Yesterday, Mr. Waters
Can you cover the tool marking
reenacted
science
a
more, Jim?
shooting scenario, if you'll recall.
Jim.
I'll do my best, but
It's
stands
Paul's
up here
gun
and
that
he
stays at
says-
the same house. Isn't a serve, Jim. Back to the tool marks.
shoots Paul in the chest one time. And 999,999 times out of a million, that person is dead. He puts his shotgun down, and he has a 300 blackout right here because he is so smart and so diabolical that he's going to stage it so it look like two shooters. So he's got a 300 blackout here, a shotgun.
That's
and
what
he
Rob
just
said.
Took his son out, but his son was 1 in a million, he says. 1 in a million. Comes this way, so Alec has to put the 300 blackout back down, pick up the shotgun, and shoot Paul.
Isn't that how Rob said it
In
happened?
the world.
Wasn't Rob like you're
Does
looking
that
like you're
scenario
picking up a gun?
reside other than in Mr. Waters' mind? It doesn't. It doesn't. There's no evidence to support anything like that.
Actually, it makes
None.
the angle make
None.
sense. He
And the
thought
fact
Paul
that
was
he has to
dead.
go to such
He was going to switch guns, saw Paul wasn't dead, and took the
Gymnastics?
second shot. Makes more sense.
to come up with the Alec staging a two-shooter theory, I ought to tell you, there's two shooters out there.
It makes more sense that there's two shooters. Go
I ought
ahead,
to tell
Jim.
you, someone to do that. Another curious point in Mr. Waters' closing argument yesterday involves Paul's intuitive talents. You will recall that Alex informed agents that Paul was an intuitive little dude. Referred to him as a detective. That Miriam Proctor, Maggie's sister, said that Maggie referred to Paul as this little detective, her little detective. And particularly when it came to trying to root out whether Alex was still doing drugs. And then he just sort of left it there. Sort of left it there for you to then take it and run with it as if, oh, Paul must have found Alec using drugs. There must have been a confrontation down there at the kennel, and that must have been what happened. Now he didn't go that far in his argument.
He didn't
but
argue that at all.
He laid it out there for you to run with. But that was clearly the implication. And I want to tell you first, there are no facts to support that. None whatsoever.
Well, the text from the day before.
Let me add
said they were
another
watching
scenario
him.
that's equally as plausible. What if Paul the detective learned the source of drugs that were being sold to his dad? What if Paul the detective goes to that drug source, says, cut it out, that's my dad, you're ruining my family. And if you don't, I'm going to tell on you, turn you in.
To
And
who?
what if
To the law enforcement that
sources
nobody
member
trusts?
dangerous drug gang?
Yeah, there's no facts to support that.
Well,
The judge should
the
admonish
point
the
is,
jury.
there's no more evidence to support it, and there was no evidence. Those were just plausible scenarios that they were throwing out to you, and that you could think up many equally plausible scenarios. But you have to decide the evidence based on the facts that the state puts before you.
He should go to the jury
Not
instruction.
theories, not inferences, not speculation, but cold, hard facts.
Go to the jury
Mr. Waters
instruction.
also said that Alex, the master liar,
Too
accused
reasonable.
Shelley, Smith, Blanca, and perhaps another witness of lying. He never did such a thing. He never accused anybody of lying from this witness stand. Now, I've been around long enough to know that witnesses can misremember things and believe them to be true. And frankly, I'm the biggest defender of that trait in my household. I convinced myself that I remembered something accurately, and I will have an argument with my wife until she shows me photographic evidence that I'm just wrong, and that's what it takes. I mean, that happens. People misremember things. But because we point out that there was an inconsistent fact,
It's a
that doesn't
fair
mean we're
argument.
saying someone lied, and we never did that.
You all don't like the
Never did
argument. See, I like that example.
One example is Sister Marion.
Everybody feels
one
bad for
example of
Jim's wife.
misremembering. Sister Marion said that she spoke with Maggie about 7 p.m. while she was at Edisto, and that Alec wanted to come to Moselle to visit her father.
Maybe I relate
Well,
because
we know that
I'm the problem. It's
Her
me.
recollection is mistaken because
Married
we have cell
lawyers
phone
feel
records, we got
attacked.
FBI records, we got her phone bill, we got that shows she was in Mount Pleasant and then she was traveling to Moselle around the period of time where Sister Marion thought she was at Edisto. Did not happen. That doesn't mean she was lying about that. Absolutely not. That's just how she remembered it. And she also said that when she talked to Maggie, that Maggie was going to go over and visit Mr. Randolph at Alameda. But we know from the records that Mr. Randolph had already been readmitted to the hospital. I mean, that's in the records. And that Maggie knew it. We've got Maggie's text to Blanca, I think.
Yeah, the stormy weather is
in the
getting
day,
it.
saying they're putting Mr. Randolph back in the hospital. We're scared for everybody and hope Alec doesn't go down to the hospital. Well, no reason I'm pointing it out. This is how Miriam remembered
Oh, God.
it. But if she remembered it incorrectly, and that happens.
Jim and Matters are wearing the
Because
same
we point
tie.
stuff out like that. We're not saying they're lying. Now, then the same with Shelley and the blue tarp. She remembers something. We're not sure what. But the evidence clearly is, she says it was on Wednesday, June 16th.
She said it was
And we got
rumpled.
FBI cell phone forensics. We've got records, and we got testimony that Alec is in Somerville. Spent the night with his in-laws, the Branstad on Tuesday, and he stayed there toward the end of the week, and then they went to the mountains at Kiowee. So Alec could not have been knocking on the door of the Alameda house on the morning of June 16th. And Barbara Mixon came in and told you that she relieves Shelley. Shelley works all night, leaves, and goes to work at the school district. Barbara Ann comes in at 8 o'clock and relieves Shelley. And as Shelley recalled it, as the tarp was laid out when she left for work. Barbara Ann came in and said, well, I didn't see it. No time during that week that when I worked was there a blue tarp. I mean, Shelley remembers something, but she's not a blue raincoat, and it's certainly Alec could not have come over there on Wednesday. Now Shelley also says that he spoke to me about times, and that bothered me. And I called my brother. We're not disputing that, but what she didn't say is Alec told me to say I was here in 45 minutes or things like that, and frankly, it doesn't make a lot of sense because Alec kept saying You
The
get my
date
phone
conflict
records. You get my phone records, and
is-
you'll know exactly what time.
The
I
date
was
conflict
when
is
I
hard to
was there.
follow with Jim, and I didn't catch
I'll
that
get
in the
to this
testimony.
A little bit more in a moment, but Mr. Waters keeps talking about,
And I think he could make that more
oh,
clear.
he's hurrying to get over there. He's hurrying to get over there to compress the time so that it looks like he's been gone from Moselle longer than he was. Fair enough argument. I understand his point, but that point is
You don't concede that the
evaporates
government's
when you're
fair
talking
enough.
about how long you are at Alameda. It doesn't matter if he's there 45 minutes or 20 minutes.
Why
It
does the
doesn't
lie
really
matter?
matter.
Right, if the lie doesn't
Why-
matter,
how
then
long
why
he was there.
lie?
Now, I guess before you had the OnStar data, they could be saying, oh, he said he was there 45 minutes, but he was only there 22 minutes, and he spent the other 10, 15 minutes traipsing through the woods, burying bloody clothes, and getting rid of murder weapons. Well, we may have heard that in this trial.
They didn't say that, they implied
Had we
that.
not gotten the OnStar data from General Motors in the middle of the trial, which shows conclusively he drove over there and he drove straight back.
It does show that he was walking around his car for like 6 or 7 minutes before he went into the house, though, Jim.
A small point.
Are you going to talk about that?
You said there's
No.
biological material on the Polaris. I don't think that was ever tested. It certainly looks like it.
Why?
But what we've learned in this case is things aren't always as they seem. They thought they had blood on the shirt. Turns out there's no blood on the shirt. And that this biological material showed that Maggie was running toward her baby. Now, I don't know that there's any evidence which way Maggie was running or what she was running to. There's not. I mean, it's a fair inference.
She was
And
going towards Paul.
Everyone who knows Maggie
The
would know that's what she would do.
bullet wounds entered the front of
We're
her
not
body as she
disputing
was
that
heading
would be her.
towards the kennels.
That would be her mother instinct. And did that probably happen? It probably did. But it's just to state it as a fact. There's no evidence of that.
Why concede probably
One
then?
thing he also said, the cell phone backlight turning on.
I have to just. Here's the problem for me. This feels a little like a rebuttal. He's not giving a closing. He's going through the state's closing and rebutting it instead of giving his own. And that's what's bothering. But he keeps conceding the state's points and saying that's a reasonable inference. Well, your job is to say that it's not. Well, that could have been. No, your job is to say that it's not. Come on, Jim.
And I don't have an Apple phone, but so here's the issue.
Oh, well, that's the whole problem.
Because I don't have an Apple phone, I don't think. But
Green dot.
if you
Green
take the
bubble.
phone flat and pick it up, light comes on. And,
Green bubble.
And why is that important? Why is that important? Like I say, I'll probably turn this phone off. And if I'm making a point that you all know the answer to, I apologize, but it's important that you do know the answer to why this is important. It's important because now that we have the OnStar data, we know
I love all of you non-Apple
Suburban
fans.
by the spot where Maggie's phone was found at 9:08. Now, there's probably some seconds in there, but 9:08. And we know that her phone is in the woods at that point. So the question is, did Alec throw it out the window at 9:08? And the answer is, no, he didn't. Because if you throw it out the window, at a minimum, the display light's going to come on.
That
At a
no,
minimum.
no.
And when
Somebody
that display
threw it
light
around
comes
in their
on,
office.
It registers. These phones say a lot. I was lesson
Surprised?
learned in this case. It registers in this Knowledge C database, and it says display light
Lesson
on,
learned.
and it has a time that the display light came on. Well, there's no on Maggie's phone. The display light does not come on at 9:08. Okay, so means Alec didn't throw the phone out. And
Is the lesson learned to you, Jim, or is the lesson learned to
and
Alec
yesterday,
about
Mr.
how much the phone
Waters
tracks?
says every single expert testified that the backlight comes on and sometimes it doesn't when the phone is raised aggressively.
I would
That's
argue
not
that in my
true.
rebuttal, too.
Only one person testified to that. And Mr. Murdaugh, who, over the weekend, he works for Charleston County Sheriff's Department. I don't know why they didn't get SLED aid to do it, but Apparently he got a phone, similar to one that Maggie had, not Maggie's phone, had
Yeeted it
software,
around.
well, not the same version as Maggie, and he spent all weekend throwing the phone on the ground and see what would happen. Or many hours of the day throwing the phone on the ground. And he comes in here and says, hey folks, sometimes the light comes on, sometimes it doesn't. Well, our expert, Mika Sturgis, says it comes on. It comes on. And that's what we're talking about. That's what we're talking about. But folks, we wouldn't even be having this discussion if they had secured Maggie's phone and not allowed and put it in a Faraday bag so that the GPS coordinates on the 7th would not have been overwritten. And
They
they
should
were.
have taken the
so
SIM
now we
card
got
out.
a guy down in Charleston throwing a phone around all weekend.
Fair. Some guy in
Because
Charleston.
they are desperate to prove Alec threw the phone out when he went by the ring. They got no evidence of that.
That is a good
In fact,
argument.
the evidence is the contrary. He did not. And the evidence supports everything that he had said from the day he had that interview or the
Lean
couple
in
days.
how
You get the
desperate they
Homestar
are
data,
that some dude's throwing
you
the phone
get
around.
GPS data. You get my GPS data, and you'll know I'm not traveling with her phone. Never got it. Wrote over it, and now we've got a guy tossing a phone in an office. Doesn't even work for SLED. Not every expert says that. The guys even said that's not his area of expertise. So, if I've hit all.
Oh my God. Those aren't bullet points.
Oh yeah, the last one was about me. Mr. Waters says that I did an HBO interview in November 2022.
You did.
And
Maybe that's why he's doing the
references some
closing.
things I said in the HBO interview. Well, I didn't, and he knows I didn't. It was testified about. There's an HBO special. I am on it. I'm not telling anybody to watch it, but that was filmed back in, I don't know, spring, summer of 2022. I'm well before he was charged with murder. And I'm not on TV talking about his murder charges. But he wants you to think that, and I don't know why. And I took a little bit of offense to that.
Facts not in evidence. You should object, Metters, at this point.
And we object, because he was.
Oh, shit.
I was not being interviewed.
Objections overruled.
Oh, shit.
Not being interviewed in November of 2022. Not.
Facts not in evidence? Metters, we object because he was. Just argue
So
it.
I've asked why. They can't answer that. They don't have an answer as to why.
Can you follow that train of thought?
Now, how? How?
They
How
don't have
could
an
Alec,
answer as to
in
why
the time
or how.
period, we know we're going to get it. We're going to get to it. But how could he have butchered Maggie and Paul without leaving a trace of evidence within a matter of minutes? How? We went from why, now how. And the answer to the how is he couldn't. But this is the wrong question to be asking yourself. Because the question that you are tasked with answering is, has the state presented evidence that proves beyond a reasonable doubt showing that Alec butchered Maggie and Paul without leaving a trace of evidence, all within a matter of minutes? In a matter of minutes. Have they proven evidence? Do they present evidence of that? Proof beyond a reasonable doubt. He was able to make bloody clothes, bloody guns, who knows how much, whatever, disappear in a matter of minutes without leaving a trace. Without leaving a trace. Of course they haven't. A reasonable doubt is doubt that causes a reasonable person to hesitate in one of the most important decisions of your life. And here, there's no direct evidence of Alec doing anything other than he's at the kennel, 8:44, and it's just pleasant family talking about Bubba the dog getting a chicken. So the state's trying to weave this story of his guilt based upon circumstantial evidence. And the judge will charge you on circumstantial evidence, and I have no dispute with what the state put up here yesterday, because that's the law, and you're going to get it. He's going to give you the written document with the charge.
I've no dispute
And you will
because that's
see
the
in
law.
there
Right.
that when they rely upon circumstantial evidence, it's as good as direct evidence, but there's some things that it has to do to be as good as direct evidence. And what it has to do, the circumstantial evidence, is that the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. And if these circumstances portray the behavior of a defendant as suspicious, the proof has failed. That's circumstantial evidence. So what are the circumstances that the state relies upon? Well, he was at the kennel at 8:44. Paul last used his phone at 8:48. He replied to a text with a friend about a movie recommendation. Maggie's phone locked for the last time at 8:50. Actually, it's 8:49 and 50 some odd seconds, but 8:50. But, however, her phone recorded significant steps around 8:55, and we're going to see that. And the phone tried to activate the camera at 8:55. And it registered an orientation change at 9:06. And I think you pretty much understand the orientation change, but when the phone goes from landscape to portrait, or this is, beats me, but goes from that to that is an orientation change. And the phone will tell you. So it did that at 9:06. And they've got 300 casings, the extractor and ejector markings matched with casings found around the house and shooting range. So that's pretty much it. And then of the circumstantial evidence of his guilt. Now they want to say, well, he lied about it, so it's consciousness of guilt, but I'm talking about what evidence they have. Put all the circumstances together, prove he shot and killed Maggie Paul, and that's pretty much it.
They can use.
And how have they established the time of death here?
Was that clear for you?
Solely on cell phone use. Solely on cell phone use. And using the phone or not using the phone doesn't dictate or define whether you're dead or alive. I mean, I'd say most everybody in this courtroom does not have their phone with them right now. Under the state's theory, as I mentioned before, if they die while they're not using their phone, then they're dead the moment they stop using their phone. That's what they have here. That is their case. There are a number of reasons that Paul
Bring up the armpits.
would stop using his phone. First, so I got two testimonial clips, one from Rogan. Remember Rogan Gibson? If you'll play that quickly, Doug. This is Rogan testifying about Paul's phone.
You want to talk about the state being desperate? Bring up the armpits.
You were asked a little bit about Paul's cell phone usage. He was on it a lot.
He was on it a lot, yes, sir.
Yeah, and
Absolutely.
Okay, just a moment.
Absolutely. A proper
What is the
objection.
objection?
Not showing the witness, they're showing the defendant while the witness is testifying. I think the testimony was.
What's the legal basis for the objection?
It's not evidence.
Mr. Griffin?
It's a clip from the live feed of this trial, Your Honor. I can't control who is being depicted, but
You can use-
my voice asking Rogan.
Been in trial how many weeks?
6 weeks.
So we're not going to replay the trial.
That's a
You can use
clip of a few
the transcript. You can use the transcript.
I sustain the objection.
All right, take it down, Bill.
He's not going to be allowed to play that
So
clip.
you will remember that Rogan said that when Paul's phone, and by the way,
I
if
realized
you
we
don't
were a little
remember and you
behind
have
because I
questions about
paused,
it,
so I sped it up.
when you're jury deliberations,
You're welcome.
you can always ask to have testimony replayed for you through.
What?
Your Honor, can we play the audio without the video?
You're asking me, what can you do? I rule on objections.
Can you play the audio then, please?
you were asked a little bit about Paul's cell phone usage. He was on it a lot.
He was on it a lot, yes, sir.
Yeah, and
What fresh
And
hell
did
is
the
this?
battery get down low pretty regularly?
Yes, he would let his phone die sometime where he would lose it.
Well, and when it would get down low, did he have a habit of not using it to try to keep him going all the way out?
Yes, I have seen that happen before.
And have you done that yourself?
Yes, sir.
Oh,
Right, and
today.
so you'll know from the photographs and the evidence in the case that Paul's phone was at 2%, and it was on low power mode at the time. He was texting this friend of his about a movie recommendation. And then, can you play the audio only of, you remember Nate Tootin, and he testified about Paul putting the phone down when he was working around the kennels.
And how would you describe the relationship between Paul and Alex?
They had a really good relationship.
Would you say that Alex?
I don't think that's the right clue. The so there's Mr. Tootin testified that when Paul would work, he would put the phone down, forget where it was at times, and that it was pretty common for him to put the phone down at the kennel so he wouldn't get it wet. And you recall Dale Davis, they brought him to the stand.
I am just so
I think they brought him
lost
to the
at
stand
this point.
to make it seem like the hose was unraveled.
I
and then
sped it up just to get us
used
back
and
on
put
track
back.
if I need to switch
And we know
feeds.
from the video, and you can see it again, the dog kennel video, we pointed out the hose is on the ground outside Cash's kennels. And Mr. Davis says, yeah, that,
'Cause this feed's
that was not how I
killing me
left
too.
it. Someone had put it down, and then I'm going to show you.
I think we're caught back up. All right, I think we're caught back up. I'm gonna switch feeds real quick. I'm hoping the audio is a bit better. I'm hoping the audio is a little less peaky. So what the issue was with the clip is because the clip that they had pulled was showing the defendant while the question was happening, not showing, maybe we shouldn't
Right here.
show those.
Doug, can I have the Elmo, please?
Not showing, it was showing the defendant, not the witness, so it was an issue with, because the single camera feed clips will sometimes show Alex, sometimes show the witness. That was the objection from Metters. They should have dealt with that all out of the presence of the jury before the closing, the way they did in Depp v. Heard. They didn't. The judge has been very permissive on things.
Oh, that's awesome.
So I'm not surprised that they didn't bring it up to the judge. And the judge also has said, to be fair, the judge has said, I rule on objections, there's no objections. And you saw that happening again. He's like, well, can I do this? And the judge is like, I only rule on objections. So they didn't give the prosecution notice, so the prosecution didn't object until it happened in real time. That's consistent with how the judge has been ruling this whole case. He's not dealing with things in advance at all.
Exhibit 503, which is a picture of the dog kennel.
I'm just having a hard time following Jim. He doesn't have a structure, it feels.
Pointing out on top.
It feels like he's just going from the seat structure.
Dog beds, you'll see, exhibit 503.
And he's
The
not
dog
going
beds are
from
up
his
here on
own
top.
structure.
And you recall Dale Davis says that when you clean out the kennels, hose it down, you put
This
the
is
dog
just
beds
not a great
on
closing.
top. On top. So it's pretty clear from these photos, this photo,
And what I want with things
That-
is a good case,
Paul and or Maggie
good closings,
had
good lawyering.
sprayed out those dog runs and put the dog beds on top. And put the hose away, Alec testified that Bubba and Grady had on collars, and we see the collars in States 45. And so their collars hanging here, but their collars hanging here, and then there's collars here. And the dogs don't have collars on them in the dog picture. So it's a fair conclusion that after Alec
Reasonable
left,
is the word
when
you
he said
need.
he left, that Paul puts Bubba up, Paul puts Grady up,
Why'd he put him in the wrong pens?
after cleaning out the kennels, and then he goes back into the feed room to get his phone, where he was confronted.
In the feed room? How did he not see anyone get into the feed room while he was in the kennels?
Sometime later. it happened.
Tiny.
I don't know. But they are relying upon cell phone usage for time of death. The coroner said he did the armpit test, which is no test at all. It's just a guesstimate.
It's appalling, the armpit test.
Can you pull up in evidence?
And that's why the defense
now
called
we're
that
talking about
witness,
Maggie's
to show
phone.
how ridiculous it was.
Defendant's Exhibit 150.
Because it was ridiculous. And say the state, you know what? The state doesn't even want you to know who did this. They didn't go to any effort
So this
to
is
prove
Maggie's
it.
phone.
I thought he'd be banging on
timeline
about the investigation
that
more.
we put in evidence, and this is going from 8:49 to 9:07.
This closing is rough for
And,
me, y'all.
and if you'll just walk through it, you'll see at 8:49:26, last text message read by Maggie. Okay, go to the next one. 8:49:28, backlight off. Go to the next one. 8:49:31, phone locks and remains locked until recovery by law enforcement. It was locked for the last time and never unlocked. 8:53, but on 8:53, the backlight comes on. Backlight comes on. It's being manipulated. 8:53:12, orientation to portrait starts. 8:53:15, phone begins logging 59 steps. 8:53:20, there's a Siri usage, and the testimony is you can get that by squeezing the button. 8:53:24, orientation portrait completes, so it switches. And then 8:53:28, backlight is off. Next, backlight is on. Backlight is off again. And it's on again. Keep going.
I want to
And
see
then
where he's going with
8:54:34,
this.
camera use starts. It's activated by touching the camera icon or by swiping left from the lock screen. There was a question as to whether that could be from facial recognition, and Lieutenant Dove said that information resides in the Knowledge C database, but he did not look for it. Micah Sturgis, our expert, looked for it, found it, and came and told you that was not a facial recognition miss. It was from intentionally activating the phone only for 1 second. Go to the next slide. Camera usage ends. Go to the next slide.
Jim Griffin is trending number 8 on
Orientation
Twitter.
landscape starts, 8:54:44, it ends. And then 8:55, so the point is, there's a lot going on with Maggie's phone at around 8:55. Keep going. Keep going. And then at 9:03, the backlight goes off. And at 9:04, there's a missed call from Alex. And at 9:04:23, the backlight's off. And 9:04:41, the missed call from Alex ends. So let's back up to, let's go to 9:04:23, missed call from Alex. Okay, and this was the testimony on 9:04:23, and it's important. Alex calls Maggie, and when that happens, you would her backlight was on. Go back one more. So her backlight is on at 9:03:52.
Okay.
At 9:04, missed call from Alex starts. At 9:04:23, and instantaneously, the backlight goes off. Now, you heard the testimony of that means when that call came in, someone pushed on the side to stop the call. Now,
We did?
was that done by Maggie because she was over on the other side of the workshop where we see those footprints that we heard about that were never really analyzed?
They said they were Maggie's footprints. What
And
else
that
do
she
you want to
didn't want any
analyze?
noise coming through? Or was that some bad guy or bad person has Maggie's phone and stops the call? But something's going on with her phone at 9:04, I'll tell you that. And then at 9:04, the next one is missed call from Alex ends. 9:05,
Why are we talking about the fact that Alex and her
backlight
phone
on.
is paused?
9:06, orientation changes to portrait. 9:07, incoming call from Alex. 9:06:14.
I want him
Keep going, Doug.
to make it make sense, though.
And 906:52, keep going.
But
And then-
what's the summary of
Then
that?
907, her phone stops for good. Now, one of the things that you heard in this case is that orientation change was at 906 that we just talked about. And Doug, if you'll go to the,
The state is arguing that the yeet from the car could be later, I think. At this point, I don't even know what he's arguing that the
if you
state's
go to
arguing.
Defendants 156, please.
The problem is, and I told you yesterday, the
And so these are,
closing arguments needed to
Alex
be
steps on his phone that
clear.
registered during this time period.
Is this
And
clear
and
to
if you'll go to
you?
entry, if you'll look at entry 28, and if you'll pull that out, Doug.
Should we do a poll? Let's do a poll. Magdalena, can we end the poll we have now about how long we're
All
going
right.
to be here because
So-
I've slipped
so
into the
28
twilight zone?
This is
I
between
don't know what day it is
902,
anymore.
18 and 906:47. And this is the time period that Mr. Waters in his argument said was scurrying around because he took,
He called him a busy
Can-
bee. He
let's
did.
bring it back a little bit more,
He
please.
did that.
So can we do it so we can see the whole line? Just, that's fine. So that, so here we see line 28 between 902 and 906.
So he's arguing
There's
he
283
couldn't
steps,
be making the calls because he's a.
and it went 208 meters. So I want you to first, and so they take the position that this is him scurrying around. But if you do the math, which we haven't done here on this document, but 283 steps in 269 minutes, excuse me, 269 seconds, turns out to be 1.05 steps per second. 0.05.
On the treadmill?
1.05 steps per second.
Wasn't that the state's quip?
Multiply that by 60, you get 63 steps per second. And if-
What? 63
Ladies
steps
and
per
gentlemen,
minute.
this is a slow walk. 1 step per second. 1001, 1002, 1003, 1004, 1005. This is Alex scurrying around.
Barber's phone
According
demonstration
to
was
the
better,
state's
Jim.
case.
Not sorry.
And if you look at the distance in meters,
Use your
on the
phone.
last,
Bust out the
I guess to
timer
the house at 7:55,
and show it.
8:55, he goes 203 meters before it stops registering. And then one thing you will remember during this time period, between 902 and 906, at 906, Maggie's phone has an orientation change. Her phone has moved from here to here, but what her phone doesn't have, go to the second page. What her phone doesn't have are steps.
Chat, y'all are the real
Are steps.
MVPs
And-
right
And
now.
Lieutenant Dove testified that.
Because reading the chat is helping
Yeah,
my
it
brain
doesn't
stay
look
engaged. Because my
like
brain is
anyone-
fighting to stay engaged.
when-
Fighting.
that
And I want to know
her
their
phone
theory
is
of the case so
moving
badly.
At 906, but there's no steps being registered. Alec is walking from 902 to 906.
Why don't you make an exhibit to show those side by side, though?
They're the reason that Maggie is not, excuse me, Alec is not walking with Maggie's phone.
I think
That's
Maggie's
the
phone is important.
Timeline data that I wanted to review with you. The, if you'll go to Exhibit 524,
I think Maggie's phone is very important for the defense. I don't know if he's delivering that information
Defense
well
Exhibit
because I'm
524,
so
please.
lost in how he's presenting it. But the fact that the phones couldn't have been moving together is the point he needs to hammer home. It
Yeah, state's
couldn't have
524, I'm
happened
sorry.
the way
You
the
have that?
state's saying. It couldn't have been. But he's
So if you'll go
not
to the
making it
slide,
clear.
where, no, sir, not 38. Do you have the whole document or you don't? Oh, yeah, we'll drop that, okay. Well,
Their phones not
I
moving
mentioned
together
earlier,
is
and
very
so
good evidence for the
State Exhibit
defense.
524 is all the OnStar data. You will see there that he goes by the spot at 908 where Maggie's phone was found. And there was testimony that he sped up after he went by there. He sped up to like from 42 to 45 and went back down to 44 miles an hour when he went by there. He's not speeding up when he goes by the area where Maggie's phone was found, whenever it was tossed. And then they have, a chart or slide that talks about how long it took him to get over there and the speed that it
Give your
took.
closing.
And Mr.
Stop worrying about the state.
Mr. Waters was arguing to you that compressed the timeline. The faster he gets over to Alameda, it means that he's gone longer from Moselle, and
Distance.
it gives him a better alibi because, as you know, he's orchestrating this alibi, and so he's driving fast over to Alameda according to their theory, and we
state
graphed
is
it out,
saying
and
he's out.
and
Okay.
he's driving, he's passing some cars, and he is, he's a fast driver. Okay, so they say, oh, he's compressing the timeline. Compressing the timeline is what they say. Compressing the timeline.
I submit to you, ladies and
But then
gentlemen,
they say,
he just
he
drives
fast
fast.
on the way back.
Yep.
Why? He's driving the same speed over there, same speed back. There's no reason to compress the timeline coming back. I mean, you'd want to be driving slow as you can to make it appear you've been gone a lot longer. I mean, he
Why?
drives the same speed from Moselle to Alameda as from Alameda back to Moselle. It takes him the same amount of time. He's not compressing any timeline at all. And
There's the argument.
what's the most curious part?
He's not compressing a timeline. He's going to visit his ill mother because
Maggie's
his father's dying.
phone? About Maggie's
Argument,
phone?
Jim.
What's most curious about it is Alec has her password. Alec, if he is wanting to
Yes.
change the timeline, when he calls her phone, he should answer her phone. When he texts her, he should reply to that text to show activity on her phone that she's still alive. If he is manufacturing a timeline by speeding,
That's a good
the
point.
easiest way to do it is use both phones, talk
Yep.
on both phones, and he did it. And this whole thing about using Maggie's phone, driving Maggie's phone, throwing Maggie's phone out is
This makes sense.
such a stretch for them to come in and try to put her phone in his hand. And then you start thinking through, why would Alec take her phone and not Paul's phone? Let's start there. Why would Alec take her phone and not Paul's phone? That's the question I don't have an answer to. It makes no sense. It makes no sense why he would take Maggie's phone. If there's something on there, he knows her password. Put it in. See what it is. We know from all this phone data, her phone was never unlocked. And he had the keys. So if he's taking her phone to unlock or to do something with it, he didn't. And so why? Why?
Right.
And these are circumstances that have to be consistent with each other and have to point conclusively to the guilt of Alec Murdaugh.
He needs to argue.
Beyond a reasonable doubt.
You don't know why and you don't know how.
And these circumstances
That is your
just
doubt.
raise more questions, ladies and gentlemen.
Yes.
Raise more questions that we wouldn't have to be dealing with if they had just simply secured
Done their
Maggie's
job.
phone in a Faraday bag on June the 8th when they got it. We wouldn't be here.
If they had secured Maggie's phone, we wouldn't be here. I wanted him to.
So we
I
do know
really
from the
wanted him to
timeline
wrap
that,
up with
that Alec left the
why,
property at
how,
9:07.
questions, doubt.
Were they killed before he left? I don't know the answer to that.
Neither do you, ladies and
I
gentlemen.
don't know the answer to that. But
Tell them they don't know the
we do
answer to
know
that,
If
Jim.
he was in the house
They don't care what you know.
when the shots were made down at the kennel, that he would not have heard them. We had decibel testing from Mr. Sutton. Now they were angry with Mr. Sutton's angle test. They were angry, not angry, but they challenged his conclusions on a lot of things. But they didn't touch his acoustic testing. Didn't doubt that. Haven't challenged that.
Because they don't
So
think
if
he was
he's
in the house.
And shots are going down, ringing down at the kennel, he doesn't hear it. He doesn't hear it. Now, they say that sometime after 8:44, and they peg it 8:48, 8:50, because that's when Paul last responded to a text from this
Oh my God, Jim, they said
friend of his.
8:49.
But they ignore the fact that it had to be cleaned up. And
After
I think
8:49.
Buster testified that takes 10 minutes at least to get the dogs in, clean up, and et cetera. And then there's all this 8:55 stuff going on Maggie's phone. But let's take him at their theory at 8:50, after having a pleasant conversation, talking about is it a guinea or is it a chicken, and Bubba, and getting,
I thought we were talking about acoustic
so 4
testing.
minutes later, let's go ahead and kill my wife and my son because I got questioned at the office today by Jeannie's secretary. Okay, that's their case. So let's run with it and see where it takes us. Well,
Don't run with
takes
the
us
state's
that
theory.
He leaves the property at 9:07. So from the moment
Oh, good.
so
Timeline.
he's got, if it happens at 8:50, he's got 17 minutes. 17 minutes. He would have to be a magician to make all that evidence disappear. As you heard, under either Dr. Kinsey or Mr. Palmbach, Dr. Reamer and Dr. Kinsey, Mr. Palmbach, and Dr. Eisenstadt, either way, the shooter's covered with blood on Paul's shooting. And that's what all that testimony was about. It wasn't about trying to figure out who's got the right angles. The whole point of that is, while we ended up having to get our own experts, is to prove the shooter
We
is
had to get our
covered
own.
in
They were so
biological
incompetent, he
material,
says, we had to get our own.
covered in blood,
The implication.
covered in everything, because of the blowback. And it wasn't until on reply that Dr. Kinsey said, oh, well, there'd be blowback under my version too. Blowback meaning blood, biological material from killing Paul. So the shooter's covered in blood.
Why is
The
that
shooter's
upset
gun
out?
is covered in blood. And that there's not sufficient amount of time to clean all that up, make all that disappear. And
Thank you,
then
Nurse One Mate, for the super chat.
call your son Buster, driving to visit your mother, who he got a call from Barbara Mixon earlier today and said your mother's agitated because your dad went back in the hospital and you might want to check on her. He goes to check on her. He calls Buster. And does he say, hey, Bus, I just blew your mom and brother up. You should see the damn mess. Are you kidding me? He calls Chris Wilson. Normal conversation. He calls his brother John Marvin, talking about his dad. And then he goes over there and he sits down with Shelley and sits on his mom's dad. And he stays there 20 minutes, not 40 minutes or 22 minutes. I don't know. The records show what time. But the fact of the matter is, he's got no blood on him. He's acting normal as every day. He is the same old Alec. Yet their theory is he just blew the people he loved the most in this world, blew them away. Now, We'll talk a little bit about the angles that Mr. Sutton did, his reverse trajectories on the
Oh no,
on the
Millie,
shots.
it's a hot mess.
And I mean,
We'll talk about that at the break.
they're having a good time joking about the size of the figure in the pharaoh, saying, oh, it must have been a 12-year-old kid, and it's 5'2", 5'4", and
They
you know,
did joke about
let
it.
them have their fun, but that's not what the testimony was. Testimony was that the barrel of the gun has to be at that level to make the shot into the quail pen. We didn't take the measurements. SLED took the measurements.
They did.
And so, yeah, could a 6'4" person get down to that level? Sure.
What?
And Mr. Sutton says that's not a
What?
natural shooting angle. Could
Wait,
a 6'4"
what?
person
What?
get on their knees? Sure. Shooters are in movement.
Why are you
And-
conceding that?
And a 6'4" person's going to be moving around on their knees? I don't think so. But, you know, the most common sense thing here is there were two shooters. Because there were two guns, and as Mr. Palmbach said, one gun is high capacity, holds 10, 20, 30 rounds. And if you're going down to execute somebody,
His expert said
one gun's enough.
someone at 6'4" could
I'll
not
take
do
another
this.
gun that
And
only
he's in
has 3
closing
shots.
saying, yeah, someone at 6'4"
it's-
could have done this. What?
And Dr. Kinsey agreed with the angle coming out of the quail pen, so that the angle puts it pretty far away from the door of the feed room where
What is
Paul
happening?
killed. But
Talk
it's not our
about
burden.
the state
Not our
expert.
burden. It's their burden to prove to you, based on circumstantial evidence,
The state,
that all the circumstances are consistent with
The state
each other
expert.
and point conclusively to the defendant's guilt beyond a reasonable doubt. And those facts are just not consistent. Those facts are just not consistent.
the state's expert said they couldn't exclude 2 shooters. Therefore, you can't exclude 2 shooters as a jury. Jim,
I won't say a word about
Jim, state expert.
condition of Paul and Maggie, particularly Paul. I'm not going to show you any photos. But I think you would agree that it was so bad. It was so bad. And Alec,
Oh my God.
in the back of the car,
How is this the closing?
me in the back of that, you could see me on the camera, sitting there and talking to Agent Owen and Agent Craw.
Because you're
And
basically
he
a witness
says
in this
it was
case.
so bad, they did him so bad. Agent Croft misheard that and said, he said I did him so bad. And I think the evidence is, everyone who's listened to it and everyone who knows what Alex was talking about around that time says they did him so bad. And Agent
state
Owen
didn't
was
really
in
bring
the
that
car,
up.
and he doesn't say to you, oh, he actually said, I did him so bad. I think we can put that issue to rest, but that issue points to a bigger question. What would they be saying in this trial if that conversation wasn't videotaped? What would they be saying? We know Agent Croft would be saying, he said, I did him so bad. And then where would we be then? I am grateful to SLED that they videotaped that, so that you'll hear it if you have any questions. I don't think you should.
It's a good argument
But-
for the defense.
They did him so bad.
What would you be
That is
hearing
for sure.
from SLED if it wasn't on tape?
Another thing that we're going to clear up
Unless
right now
the jury thinks it says I, and then
is
it's not a good argument.
Alec's concern for Buster. You heard that, and you heard that in Mr. Waters' closing. That in the statements that Alec made on the roadside shooting in Labor Day weekend, where he tried to arrange assisted suicide, that he told officers that there's no danger to Buster.
I think he should have ended on
Of
the
course,
point.
there was no danger to Buster because of that roadside shooting, because he knew
SLED.
who shot him, Curtis A.D. Smith. He knew he was trying to get himself killed. But from that, there's going, the reason he knows there's nothing to worry about Buster is Because he knows he did it. That's what was just argued yesterday. Well, Deputy McDowell, in a body cam video that's in evidence, captured Alex speaking to Buddy Hill about his concern about Buster's safety. And will you play that now, Doug? It's in evidence. I don't have the exhibit number.
That's evidence. He could play the video. Why didn't they play that earlier?
I think the...
Did we ever hear that earlier?
Can y'all get a police officer with my oldest son in Columbia? Can you call Buster? No, I haven't told him yet.
Did you hear that? Can y'all get a police officer for my oldest son in Columbia? What about Buster? What about Buster?
Escort
Can y'all
to
get
get
a
him there
police officer
faster?
for my oldest son? Buddy, can y'all get a police officer for my oldest son in Columbia?
Was
That's
it to
Buddy
get
Hill,
him
sheriff.
an expert? Or to get him an
Anyone
escort
come
to
in here
get
and
there
tell you
faster?
he wasn't concerned for Buster's safety? Once again, I'm grateful Colleton County
Why didn't he
Sheriff's
play
Department
that sooner?
has body cams. 'Cause now you know. You know Alec was concerned. You know Alec asked for a police officer for his son in Columbia, Buster.
I just want to know if he was asking for an escort to get him down there faster. We never
I'm
heard
almost-
that.
I'm
We never
I'm
heard
almost
that.
done, I promise. But I
It's
do
in
wanna
evidence, but they
talk
never
about
played that
Alex's
whole
misstatements
interview.
about time. Alex told
And the defense never
Deputy
played
Owen
it.
during the interviews that, well, first, Alex's statements about time are not lies. They were just misstatements. And even, like I said, Deputy Owen says people make mistakes about all the, Agent Owen, they make mistakes about time all the time. And they do. Now, Mr. Waters is critical because Alec was wrong every time he gave a time estimate.
Mr. Waters told you
Turns
this
out-
would be a 3-week
Mr.
trial.
Waters is probably right about that. Whether the time period is inconsequential or consequential, he's wrong about it.
Mr. Waters
And
is wrong
the,
on time, too.
And we had brought in, Alec had told deputies in an interview that he got home at 5 o'clock, and that's not true. That he went to work that day at 8:30, that's not true. And so he is just wrong on times. But what was consistent whenever he had an interview,
He was
he
wrong.
said, you get the records, and it will show what time I did this, what time I did that. It will all be in the records. And guess what? They are in the records. And when the records show that his time estimate was wrong, they jump up and down. They jump up and down.
They do that.
The statement to Deputy Green, he says, I've gone to my mom's for about an hour and a half, and I last saw them 45 minutes. Now that I don't know. I frankly don't know if that's wrong or not. I mean, he's talking to Deputy Green about 10:30. Hour and a half from 10:30 is 9 o'clock. I mean, he left. He left at 9. He left at 9:07. But that's that. The question about what he did when he got down to the scene, and he said he ran up to Paul and Maggie, and he left his phone, and then he went back to get his phone, and then he's talking to the 911 operator, and you can hear it, and he says, I've been up to it now, it's bad. He doesn't remember the sequencing, and I don't think anyone should hold that against him. Mr. Waters gets up here and says, Maggie was running to her baby. Alec was running to his baby.
Oh. Oh.
And can you imagine what he saw?
I think this is why they picked
And
Jim
is
for the
it
closing, and I think this is why Jim shouldn't have done
Evidence
the
of guilt
closing.
that he doesn't remember what the sequencing was in that moment? Is that evidence? Is that evidence of guilt? Or is that evidence of trauma? This is a guy that then went to get a 12-gauge shotgun,
He should have paused.
and he put 16-gauge shells in it. He knows the difference, but he didn't know that night. And I'm not quite understanding what the state makes of this. Did he not
He
go
should
up to
have
their
given
bodies?
himself a pause.
Because the forensic evidence sure speaks to the contrary. What we have is Maggie's DNA all over his T-shirt, and you heard that from Agent Zapata. We have Paul's DNA on his T-shirt. How did he get Paul and Maggie's DNA on his T-shirt if he didn't touch them?
But how did he get their
If
DNA with
he
no
brutally
blood?
murdered them, hosed off down there next to their dead bodies, got in the golf cart butt naked, drove to the house, changed clothes, went over to his mom's, goes down, calls 911, then searches for Whaley restaurant menu and checking emails,
Text.
waiting for the police to show up. How's he get their DNA on his body? Because it's on there. The forensic lab tells you that. Because he went up to them and touched them. And then there's a spot of blood on the Suburban steering wheel that was Maggie's. And we know that the Suburban was never down at the kennel, thanks to the OnStar information. Thanks to, I'm not sure that was an accepted fact until OnStar sent their stuff in, but the Suburban never went down to the kennel until after he returned back from Moselle. So we know the blood got on the steering wheel after he checked Maggie like he said he did on the 911 call. And then there's a spot of blood on the gun that he went to get. And then there's GSR. There's GSR. There's 3 particles of GSR on his shirt, 3 particles of GSR on his shorts, and 1 on his finger. And the SLED agent testified that's consistent
That
with
shit gets
transfer
everywhere.
GSR when you pick up a gun.
Yep, that shit gets everywhere. It's interesting he keeps saying that Alec went back from the
So,
kennels
but
in the
really,
golf
we're
cart
back to the lie. We are back to the lie.
naked.
Because that's all they have in this case, is that Alec lied to them when he last saw them. And he shouldn't have. He shouldn't have. And he said, what a tangled web we weave once we start to deceive. And once he lied the first time, he was stuck with the lie, and he continued to lie. And he shouldn't have. He shouldn't have.
But you can't.
And he told you, what was going through his mind. Probably wasn't rational, but he was in the throes of an addiction, and he had just found his wife and son murdered. And he's being interviewed. He'd been swiped for GSR, and he does think David Owen is the guy that investigated his friend.
He told you that.
But he was wrong, and he told you. Turns out he was wrong, but I thought that's who it was that night. And he was under investigation. He was being accused of obstructing the boating accident investigation. And he's under investigation by SLED for that.
Did he know that at the
He had
time?
all these skeletons in his closet. And he was wanting to get them away from him and looking for the real killer.
Did I miss it? Did they prove that he knew he was under investigation by SLED for the boating accident?
The state in this case has gone to lengths trying to, through a sleight of hand, convince you of this and show you that, and without convince you of guilt,
You're saying they're reaching?
without showing evidence of guilt, convince you that he murdered his wife and son because of his financial misdeeds were going to come out. which is about the most illogical thing imaginable, and there's no evidence of that. And then the state brings all these shotguns in here, and I'm not going to pick every one of them up, but the forensic evidence on these shotguns is
Nothing.
they can't be excluded. Well, okay. They can't be included either, so you know nothing more about these shotguns than you would have the day you showed up for jury selection.
The forensic value of the
There's nothing to
shotguns
know
is
about
shit.
them. Can't exclude them, can't include them according to them, but we do know there's no blood, guts, brains on any of the guns.
None of those are the murder weapons.
From the shooting.
Yep.
Under everybody's interpretation.
And if they
of
didn't
how
bring all the
Paul's
guns
murdered.
in, the argument would be they didn't even
They-
check all the guns at Moselle. So
I mean,
how do they know those
want
aren't
you to
the
think that
weapons?
because you own guns, that you should be viewed differently? I don't know what else to make of that. I don't know what else to make of that.
Well, you know what to make of it. Y'all brought
When
up
this trial began with opening statements on January 25th, Mr. Harpootlian asked why.
Oh, that's right. It
Why
did
would
start in
Alex
January. We're in
execute his
March.
wife and son in cold blood? And here we are, 6 weeks later. And you've heard weeks' testimony about Alex's financial crimes, drug addiction, and lies. But after all that, the state has failed to provide a satisfactory answer to this question.
Ladies and gentlemen.
Why?
You don't know why.
The state
You don't know
cannot
how.
provide an answer to this question because the answer is he would not, under any circumstances, murder those that meant the most to him. Your oath requires that you hold the state to the exacting standard of proof that the state must prove the defendant's guilt beyond a reasonable doubt. And when they rely solely on circumstantial evidence, these circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. And if they merely portray the behavior of the defendant as suspicious, you must find him not guilty. The state's evidence fails to meet these requirements. Circumstances don't point conclusively to Alex's guilt. Far from it. Mr. Waters wants you to believe that Alex slaughtered Maggie and Paul on June 7th and repeatedly lied and changed the story to fit the timeline and evidence. As it turns out, in fact, the state is the one that's been manipulating evidence to fit their theories of guilt, which changed over time, from the date of these murders until yesterday. In the absence of forensic science, a reliable investigation, the guns, blood spatter, the time and opportunity to have committed these murders, you're instead left to make inferences about all sorts of interactions and behaviors. Prosecution wants you to
Talk about the head
view
bobbing.
the evidence through the diabolical monster lens that they have tried to paint, but the law requires you to view it through the lens of innocence, where none of these things, individually or taken together, prove conclusively to Alex's guilt beyond a reasonable doubt. Up until now, you've not been able to say a single word. Can't imagine how frustrating that must be.
Same.
But soon you will have the most powerful voice in this courtroom. With your words, you can let everyone know that in a court of law, only evidence and the burden of proof matters, not gossip, innuendo, opinions, and most of all, not theories layered on top of speculation.
He's wrapping up.
With your words, you can let the state know that they don't get to obtain an indictment by misleading a grand jury and then bring you before you a case built on theories, speculation. There are two words that justice demands in this case, and those two words are not guilty. The oath you've taken in this case is to follow the law, to follow the Constitution, and to hold the government to the burden of proof. And it requires a verdict of not guilty. On behalf of Alex, on behalf of Buster, on behalf of Maggie, and on behalf of my friend Paul, I respectfully request that you do not compound a family tragedy with another. Thank you.
Jim Griffin got very emotional at the end of that closing.
Ladies and gentlemen, we'll send you to the jury room for a break. Please do not discuss the case.
which I do not criticize. I think that Jim Griffin is in an impossible situation. I'll criticize more of the closing, don't worry, as I did for the prosecution. But Jim is so close to this case. But then he just winks at Dick Harpootlian. Did you see that? Jim is so close to this case.
Everyone will be seated.
The wink killed it for me.
So, Mr. Meadows, are you closing on behalf of the state?
Oh, goodness.
Do you have an estimated length of time that you might go?
Time is a construct.
40 minutes.
You ready to go?
If you give me, I just need to go to the bathroom.
Facts.
All right, we'll take a 5-minute recess.
I think this judge is going to try to get Metter's rebuttal done before the lunch break. Do a 40-minute rebuttal, 45-minute rebuttal with Metters. Send the jury to lunch. It's 12:27 in the East. 5-minute break. Send the jury to lunch. Come back, instruct the jury, and then let them start deliberating this afternoon. Metters spitting facts there. Are you ready to go? I just need to go to the bathroom. True. I had a lot of judges that would not let you go to the bathroom. They're like, too bad. Let's go. But once the jury's out of the room, it's a lot easier. The wink at the end, Jim did get emotional. I don't think that was, I don't know. I don't think it was planned. I think it's because Jim is so close to this case. How it comes across to the jury, we will see. The jury didn't see him winking at Poot when he was done. They didn't. We did. The jury didn't. That was a very difficult to follow closing for me. Let's just wrap that up and get to your questions. We've got a quick break. The defense has finished their closing. I think there were some very good points within it. It's just whether the jury will be able to slog through the things that felt disjointed. There were parts of the closing that were hard to follow. It didn't feel to me that Jim had planned his closing to incorporate the state's points. It almost felt like he was going through the state's closing and then rebutting their points in their order instead of making closing his own. He makes a good point that got lost in the middle of why and how, and I would have liked to have seen that been the theory of their case more. No, the state does not have to prove motive, but the state opened the door to motive. They've talked a ton about motive. They brought in all the 404 about motive. And so I think it's completely fair for the defense to say, they want you to believe this motive is the why he would do this. And it makes no sense. But he didn't deliver that cleanly. It makes no sense. They're at the kennels. Everything's fine. They're talking about Bubba and a chicken and a guinea and then what? And then he annihilates his entire family. 3 minutes later? That doesn't make any sense. And I don't think he did it cleanly. It was woven in there. But the why and the how, and then build in the fact that they are rebutting the state's manufactured alibi with manufactured evidence. And go through it. The state is manufacturing these arguments. The state's sitting here talking about throwing fucking phones in somebody's office. He wouldn't say fucking in court, but you know. Throwing phones in an office. And the fact that Alex's head is going like this. That is what they're basing their case on. Throwing phones and his head bobbing. And a shirt that they said was covered with blood until they did the confirmatory testing that their investigating officer didn't even look for. Wasn't even waiting for the confirmatory testing. You know why he didn't see that email? I'll tell you why he didn't see that email. Because he was so sure it was Alec and that shirt was covered in blood. He wasn't waiting for the confirmatory testing because that investigating officer's mind was made up. So he wasn't looking for the confirmatory testing because he didn't even think it was necessary. And it was. You know why? Because the confirmatory testing said no blood. The state made assumption after assumption after assumption in this case, and their assumptions don't make sense, and their assumptions don't equal guilt. Rely on your common sense, ladies and gentlemen, not the state's flawed assumptions. It's why not that? Why not that? He's telling you all about the time, and his time is wrong. You know what's consistent in this case? His time is consistently wrong. Not because he's lying, because he has literally no idea. And he's trying to make it up because he knows he's in the circle, and he's trying to give answers that he can't. But that, you can't convict him on that. Of course he is. Because the state is breathing down his neck. They're investigating him. They put a case on his friend who was acquitted. They're investigating him for obstructing the boat case. They've charged his son. Of course he's concerned about what they're doing. He doesn't trust them. Of course he called all of the attorneys he knows to the scene to support him, and because he doesn't trust them. Ladies and gentlemen, do you? Do you trust their investigation? They didn't do this. They didn't do that. No footprints. No footprint markings. No fingerprints. Why not argue that? And then what you get from this state is somebody sitting in their office throwing a phone around, and that is supposed to be the evidence that you rely on? That evidence? Their coroner didn't even bother to establish a time of death. He put his hands in Maggie and Paul's armpits. They deserve better. But better for Maggie and Paul is not you convicting Alec Murdaugh of this murder on evidence that's based on assumptions. Where is that closing? Where is it? I don't know. But we didn't see it. And then go through the timeline. I just don't know. I just don't know why they didn't bring a clean and concise and outraged closing. If anyone has a right to be outraged, it's Jim. If he believes Alec didn't do it. They have charged his friend with murdering his wife and son on what he is saying is manufactured evidence and assumptions. Where is the outrage, Jim? There's time to bring emotion. Now is the time to bring it. Tell them it's preposterous. Tell them it's beyond all logic. Tell them it's beyond all doubt. Tell them it's beyond all probability, even. Ladies and gentlemen, we can't get to anything. It's not probable. It's not possible. It's not likely. It's not beyond a reasonable doubt, because all this case is doubt and assumptions and questions. You don't know how, you don't know why. You cannot convict him if you don't have the answers to those questions. And the state has not presented them to you with anything more than conjecture. That's not evidence. What are the facts that you have? I don't know. I'm going to get to some questions. I thought we would see more fire from Jim. And I'm disappointed that we didn't, because there's reason for it. If Jim believes that the state has manufactured evidence, is basing their case on conjecture, then why not let them see the anger, the frustration, how appalling it is? Make the jury feel your disgust that the state would reach so far as to charge this defendant with the most unthinkable crimes. Argue that. This is the time to bring the emotion. Instead, Jim Griffin looked defeated. He looked apologetic. He's like, ladies and gentlemen, you know. I don't understand why there was no fire from him. We saw emotion at the end. We saw sadness for Paul and Maggie, who he knows. But where is The outrage. Maybe it wouldn't have played with this jury. Maybe he thought it wouldn't. But if he believes the things he said in his closing, then you have every right to be mad, every right to be outraged, every right to argue to this jury that what the state is doing is preposterous. And then you know that Metters is coming up. I don't know if I'm worried about Metters coming up if I'm Jim Griffin. Metters isn't always clear. You know what Metters is going to bring though? The drama and the emotion. Metters loves the drama. Metters is going to bring emotion. Hopefully it's clear. Just Jim's closing did not feel like zealous advocacy to me after 6 weeks of trial. It just didn't. And I'm surprised by that. And I don't know why we didn't see it. I've told you before, I love a closing argument. I love a closing argument. Closing argument is the time to show the jury how they should think about the case. And he started with, I don't know why they call it closing argument. I'm not here to argue with you. You're here to argue your case. I don't know why that was the choice. I just don't know. All right, well, we'll see. At some point, I'll have to just juxtapose my closing for the state from yesterday, my closing for the defense from today. There's a lot I left out, but there's a lot I left out, and there's a lot more I would do if I was making the closing. But there are arguments in there that we just simply did not see. And I thought that we would. And I'm surprised that we didn't. But y'all have a lot of questions. Quick bits. We're professionals here. IDK James, good to see you in the chat today. EDB, I know of 13th juror. I know they can grant JOA. Can 13th throw out jury verdict and find guilty? I watched a Georgia Supreme Court on something similar, an old SC family. My heart hurts, especially how it makes the state look. I'm not sure what you mean by the 13th juror, IDK James. They can grant a judgment notwithstanding a verdict, but I don't think we are going to get the jury determining that they can't come. Well, I think we could get the jury determining that they can't come back with a verdict, but I'm not quite sure that they will throw out the jury verdict and find guilty. You're talking about the judge coming back with a judgment notwithstanding the verdict? The judge isn't going to make a determination in this case. The judge is not going to render a verdict. If he's convicted, the defense will ask for the defense will ask for a judgment notwithstanding a verdict to set aside a verdict, but it doesn't go the other way. The court cannot, if that's what you're asking, the court cannot acquit, or the court cannot convict this defendant. So, I know we have a couple other
Bring the jury.
super chats I want to get to. We are bringing the jury. And again, I'm surprised at that closing. I really am. Jim has a tremendous amount of experience. I thought we would, I don't know. I just thought we would see a different style of closing. Interesting that Jim's not sitting next to Alec at all. And Alec is now on the end. I guess they're going to wait to object. IDK James said coroners in South Carolina are horrible. I stated before you did. Colton coroner is more than a few cards short of a deck. I'm so glad light was brought to this. Like I said, SC boy, I only know Lafitte, not the rest. He used to come to supper club. The coroner is an interesting thing. It was a very odd thing for me. Most coroners, even if elected, require a level of medical training, like, to be doctors. It was just odd. Chantel said, EDB, I think the last part was better. I think the end of Jim's closing was the cleaner part of his closing. It just didn't feel linear. And in this
you.
case, the jury needs
Ladies and
clear.
gentlemen, the state gets an opportunity to do a rebuttal. Mr. Meadows.
Cat Yab, is this as bad as it feels? I think it feels bad to the chat. I'm gonna.
Good afternoon.
Has Jim's closing been clear? Yes or no?
On behalf of Attorney General Alan Wilson,
88% of you said
Tom
no.
Lincoln, Deputy Attorney General Craig Waters, and this entire team, and I want to name them all, but thank you for being here.
So
Thank you for the
88%.
attention you've given this case.
Jim's closing wasn't clear. I'm gonna
Being
do
a
another
juror
poll in
is
a
not
minute.
an easy job. I'm not a jury watcher. I don't sit and stare at jurors, but goodness knows we've been here 6 weeks. I have looked over occasionally. Not to pry,
No, the judge can't
but I've
convict.
noticed when I have looked, you've all paying attention, so thank you.
The jury can only do that.
Thank you.
The judge can only say no
I'm not
reasonable
gonna do that
jury
long.
could convict. Metters has wandered away from the microphone, shockingly.
Your clerk, Ms. Hill, has done an outstanding job bringing the world to Colleton County, bringing the world right here with the hospitality of her grace,
The world is
making
watching.
everything as convenient as she can. But the one thing she didn't do and couldn't do is give you a booklet on how to be a juror. 5.5 weeks ago, when y'all got here, 6 weeks ago, she didn't have that pamphlet for you because they don't exist. There's not a book on how to be a juror. But you have been preparing for this moment in this courtroom
He's arguing
to
against.
decide this case
He's arguing
your
against.
entire
the hang.
life.
You have
And it's called life.
to determine.
It's called living. It's called experiences. It's called interacting with your spouse, your children, your neighbors, your coworkers, your good experiences, your bad experiences, evaluating people, and deciding what's credible, what's believable. It's true in every case I've ever tried in my 34 years of doing nothing but murder cases.
What? How do you go 35 years and do nothing but murder cases?
And I agree with Mr. Griffin.
I have questions.
When I looked at this case the first time, I said to myself, this is a CSC case. Now, in our world, that means criminal sexual conduct. It's not a criminal sexual conduct case. This
What?
is a common sense case. And you didn't leave that common sense with you when you came here 6 weeks ago. It's with you now. It's been with you during the 6 weeks.
The law
here.
nerds have a
And
lot
you're
of common
taking it
sense.
back into the jury room.
And we got a lot of questions.
I've been listening yesterday and today, and we all have, about law enforcement didn't do this, law enforcement didn't do that. I think they actually said they fabricated evidence.
They did say that. What do you mean you
Putting
think?
law enforcement on trial.
They did say that.
I once called Mr. Harpootlian in a trial an automatic smoke screen machine. I think what the defense is doing in this case is more like an eclipse. You remember that eclipse on August 17th of 2017, where it kind of got dark for a little bit, and the birds started chirping, and you felt like it was dark, and then it cleared, the eclipse went over, and the light came back.
The automatic
That's what the
smoke
defense is
screen
doing.
machine.
Taking you away from the facts, from the credibility, and saying, wait a minute, there's an eclipse here, there's a smoke screen here, look at that. And somebody said the word offensive. I find it offensive that a family
Offensive.
with a great-grandfather, a grandfather, a father, Sylvester Randolph Murdaugh, who was good to me when I was a young man, prosecutor. He knew I wanted to do this as my job.
Sir? That's
He
not
knew I
facts.
cared about this job.
That's not
This is
facts.
the best job in the world. I tried to be solicitor 3 times as long.
That's not facts and evidence.
It doesn't get any better than this job.
Oh my
And I find it offensive that the defense, through the defendant, who was also a part-time solicitor, is claiming that law enforcement didn't do their job. Listen to me, please. Didn't do their job while he is withholding and obstructing justice by not saying, I was down at the kennels.
I don't know about
I
that.
was down at the kennels. I was down at the kennels.
That's a bit
And he's
of a
going
reach.
to blame everybody else. Is that offensive? Is that offensive?
It's not obstructing. You didn't charge him
Griffin
with
said a minute
obstructing.
ago, can you imagine coming up on the scene and seeing, can you imagine not telling law enforcement, lying that I was down there and I saw him, I was right there? Why wouldn't you tell them that? Maybe get some more evidence. Did you hear somebody? No, I wasn't even down there. Credibility.
Did you hear him say, listen to me, please? He was looking at a particular juror. Someone is put off by him, I
Remember
wonder.
6 weeks ago today,
Because the listen to me, please was to the jury specifically.
Mr. Waters' fantastic opening and talked about direct evidence. And direct evidence is something you know it when you see it. It's evidence you gather with one of your senses. You hear it, you feel it, you smell it, you touch it, and you come in here and tell witnesses, hey, this is what I heard, what I felt, what I smelled, what I touched. But do you remember when he was describing circumstantial evidence? There was a storm that day coming. Part of his theme, the storm just happened to come. And you could hear it coming. And then, during part of his opening, you remember it started raining? You could hear it. You could feel it. It's almost like circumstantial evidence morphed into direct evidence. And that's what happened in this case.
What?
Circumstantial evidence became direct evidence.
Transmuted?
This case is about two things. It's about being real, and choices.
What?
Mama gave me a book when I was a little boy about the Velveteen Rabbit. He's actually going off to college. Dealing with people and learning about people. and
Being a what?
tough times in life. Go get the Velveteen Rabbit and read it if you haven't already. But she just put in the front of that book,
What?
and I love my mom. Always be real. Always be real. And this case is about that defendant.
No, we're talking about the
never being
Velveteen
real.
Rabbit. I don't know what happened.
And choices, which I'll get to at my end. Ladies and gentlemen,
We've gotten to rascally rabbits.
they blame everybody but Alex. Everybody.
Well, of course they do. They're the defense matters.
Let's go back to the first. I'm not going to bring it out. But this,
Remember, this is the attorney that did this
the press release was sent out.
in the middle of questioning.
There's no danger.
Oh.
There's no danger. What did Alex not do? They showed a tape there. He's asking the sheriff, I think, to call Buster. First time he tried to call Buster, took the sheriff a while to get out there. You know when the first time he called Buster? It's about 40 minutes. Well, actually, he texted him, didn't even call him. Wasn't his first thought. Wasn't the thing after he did 911. It was later. Perhaps even when some of his friends had gotten there. Oh, don't call. No, right off the bat, if this happened, call my son. Call him. Buster, stay where you are. You with your girlfriend? Up there in North Charlotte? Go. We got some people after us. That's what's real. Don't you? You go to the police station right now.
Stop yelling
What else
at
do you
me.
do too?
Matters.
You don't talk about being real.
Stop it.
What do you do?
I'm
No,
being
I just
yelled
left
at.
my mama. She's with Shelley. Get somebody over there. Get them over there. If these people are out here to kill us, get them over there. Go, please. Take them right now. They're by themselves.
Please stop yelling at me.
I can't do that. That's where I took the guns. I can't tell them that. That's what's real. And he brings up the boat case right away. Right away. A year and a half previous. It's coming up for a hearing. Nobody's thinking about that boat case except Alice. And right then, he's using it to throw off. Here's your first suspect. Does that make any sense? They have a hearing coming up. They're going to look into resolve this thing. Nobody's out there thinking about a boat case on a Monday night. Anybody upset about that? Think about all the facts that would have to happen. They'd have to know both, as Mr. Waters said, somebody in the boat case would have to know that they're both there. They'd have to know they were there. They'd have to know that Alex just wasn't there. Oh, no, wait a minute. That he was there, but just for a little bit and went back up to the house. And they'd have to come. You know what? We don't need a gun. There'll be guns there for us to use. Yes, and that's great circumstantial and direct evidence. I'll get to that. They'll have guns there for us. They'll have guns there for us. We can use them. Does that make any sense whatsoever? Let's talk about murder.
It's
Murder
fair.
is the intentional.
I said Meadows would bring the
malicious
drama.
Killing of another living, breathing human being.
He
with malice
said
aforethought.
he was going to
What's
bring it.
malice? Y'all know what malice is?
He's looking
It's
at
the
one
name
particular
malice.
juror.
It's the evil wickedness one person shows to another.
I got
You know
thoughts
how long
about
it's got to
that.
exist? Just like that. At the pulling of a trigger. 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 Malice aforethought. It can be expressed. Rarely happens. I'm going to kill you. Or it can be inferred. It can be inferred with the use of one gun. There's no claim of self-defense here. They're claiming they weren't there. It can be inferred two guns.
Yes, it can.
Malice aforethought. And we don't have premeditation in this state. We don't have to prove premeditation. We don't have to prove motive. I think it's been proven. His world was collapsing. Mr. Griffin goes, does that make sense? Did in his mind. His world's collapsing.
Made
His
sense
world's
to
coming
him.
down.
That's
This
fair.
was the only way he could save. It's the only way. It's the only way he could save Alex. But if you don't, if that motive, well, I don't know, is that enough? Don't know. We don't have to prove motive. We're certainly there. That's one explanation. But if he's down there,
He said it's the only
and
way
he's
he
angry,
could save
don't
Alex.
sound like a real jovial there. Bubba! Don't let me forget about Bubba.
Don't slander Bubba.
Come here.
We love Bubba. Yeah. Metters is not a boring attorney for sure.
Just got angry. Maybe he got angry at Paul. Maybe he got angry, you know, you started all this with the boat case.
Maybe he's not
And maybe
good.
he just lost it.
Maybe he's not
Maybe he just lost it.
beyond doubt though, Metters.
Maybe it looked like a suicide. And then Maggie came and he had to shoot her. I don't know. Only
Okay.
one person knows. And that's why we've got the motive. That's why we say he did it.
Metters, if
But
you
we
don't
don't
know,
have
how
to
can
have
the
that.
jury know?
Just angry.
Maybe he doesn't
Did
get to
it?
beyond a reasonable
Nobody else
doubt,
did it.
Metters.
Nobody else did do it. I'm going to get to that, and that's how we prove beyond, I want to say all that. But our burden's only reasonable now. But losing it, and then you get the question, well, have you proven malice? Well, yes, sir. Yes, ma'am. 2 shots to Paul. Malicious. First one didn't do it, the second one finishes him off. 5 shots to Maggie. Not an accident. 1 shot, 2 shots, 3 shots, 4 shots, maybe 5 shots, depending on whether this one's certainly true. That's malicious. So if you find he killed him and you get to malice, I don't think there's any dispute in here about that this is a malicious killing.
There is
But
no
I've gotta go
dispute
over that with you.
about malice. I don't think.
Malice of forethought. And then the burden.
The dispute is who
The
did it.
burden on us in this case, as in every case that's tried in this wonderful land of ours, that's why this is so great, I agree with, is beyond a reasonable doubt. I'm gonna borrow one of these waters if that's okay.
Whose water did you just grab? Wait, where did he grab that
It's
from?
not beyond all doubt.
Wait, did he grab it from
If
the
that's the case, this
jury
courtroom
box?
wouldn't have been here as
From the
historically as long as
bar?
it had. The law doesn't describe
Chat,
that.
help.
Listen to his honor.
I was looking at chat. Where did he grab the water from?
And I'm not playing up to him. He is the best.
Was it on this bar here?
He's the law. Listen to him when he reads the law. Beyond a reasonable doubt.
Holy shit.
It's not beyond all doubt. We
This
can't
is,
do that.
the jury's right
Beyond
on
a
this
doubt
bar.
that would make reasonable folks hesitate to act.
Oh my God.
I was trying to retrial a case years ago and reading reasonable doubt from this ex-solicitor, Solicitor Wilson, I'll give him credit, describing reasonable doubt, and he said, sometimes, questions are just questions. You can't answer every question, and the law doesn't require it. If after hearing all the evidence, or if you're firmly convinced of the defendant's guilt, you must find him guilty. If, on the other hand, you're not firmly convinced, then you must find him not guilty.
I'm stuck. I'm sorry. I'm stuck in a loop on the water bottle. I'm going to have to go back and see it later. Because the water bottles the prosecution has are full size, and this is a half size. I think he grabbed it right off that bar where the jury is sitting.
He goes to see his mother. He goes, and you see the OnStar taking him up to the side, over near the smokehouse.
I was hoping they'd touch
We
on
submit
this.
to you that's when he went to hide the guns.
The guns are in the
Common
smokehouse.
sense. We submit to you that there's a driveway there, nice pavement, you can go look at it, nice paved driveway. Submit to you when he came, it was 9:30 at night. Testimony is very unusual, very rare. Kind of funny, Miss Nixon, who testified earlier, we talked to her recently, didn't remember any of the conversation, but said she called and said he told him your dad's not doing well. Well, he didn't go over there that afternoon when he got the phone call, when his office is right near there.
That's a good
Go
argument.
see him then. He didn't do that.
He waited.
He waited to 9:30. I don't know if anybody's got any folks that are suffering from Alzheimer's, but when they're asleep, they're tired. He wasn't going to love his mama. He wasn't going to be with her. He was going there because he loves Alex.
It's a good
He
line.
loves Alex. And he was going there to create his alibi. At 9:30 at night, use your common sense. And you remember, she said he called. What happened after that? Well, it was about 5 minutes or so. At first I was thinking, look, that's when he was going to hide the gun. And the time frame over there is so important, not for how long he was from left to come back, but it's how long he was in there with Shelley. How long he was in there. Because that's when he was hiding the guns. The guns are missing, y'all. He was hiding the guns. And what did Shelley say? He didn't stay long. 15, 20 minutes.
I like his storytelling the best
He left.
of all the attorneys that have closed. Because he's telling you a story.
And later that week, later that week,
Giving you the story.
and I don't know which one in my mind right now, I'm so tired. But one of the days she came by, I think it was after the visitation, and he says, Shelley, you remember I was here about 35 or 40 minutes? Y'all remember looking at her up there on the stand?
After the Velveteen Rabbit, once we got past that. But he's acting it out in this courtroom.
She got visibly upset. I said, what's wrong? Ask her, what's wrong? What's wrong there? Was he there 35, 40 minutes? No, sir. Why are you upset? It's a good family. You think she knew right then?
You know why Miss Shelley was upset.
He's coming back to say, hey, I was here 35, 40 minutes now visiting my mom. Shelley said, no. No, you weren't. So upset that she calls her brother police officer in Yamasee. You think she knew right then?
This is why they
And
didn't
that's
bring Miss
real.
Shelley up more earlier
That's real.
to address it now.
Shelley's real. You saw her, but body language is so important, right? Body language is so important. She's talking about the defendant. All our body language. You see Shelley's. And then one day that week, never before, never, ever before, it's 6:30 in the morning. Doesn't call. He didn't need a timeline to create for that one visit. Didn't want a timeline. Didn't want a record of that.
Huh.
He comes to see Shelley. You ever been over that time before? No.
He always calls?
What was he carrying?
I like that argument about the call
It
a
was
lot.
some blue, vinyl-like. Remember I tried to, what
Didn't want a
It was
record
like
of that
this.
one.
did you think it was? A tarp? I don't know what it was. And they try to gloss over it now. Here's one thing they didn't gloss over. You remember when she was on the stand?
I like how he retells
So
Shelley's
have you
testimony.
talked to them, have you talked to their investigators? Yes, sir. Did they record you? Yes, sir. Can I have a copy of it? And we came back and we got a copy. And two investigators, they were worried about it then, went down and talked to her. And talked to her about her times and ran times by her and asked her if she'd ever seen anybody in this blue coat. Have you ever worn it? They were worried about it. Because that's great circumstantial evidence. It kind of morphs into direct evidence. I saw him coming at 6:30. You even heard, they asked one of the experts, well, could it stay on there for 5 years, 10 years? Sure. This was days after the murder. Shelley sees him come in with a blue something. Well, where did he go? He went upstairs. Why? I don't know. Did you see it later? Thought I saw it on the chair.
He's still telling Shelley's story.
Miss Mixon sure didn't see it the next day. Now, I asked her, was there another tarp there? Well, there was a blue and silver tarp. Picture of it, too. That wasn't it, though. This was all blue. And the only other blue tarp that's in evidence, and I let it go in just so I could argue this right now, is the tarp that they showed Shelley that they got from Kmart.
They got
That's not real. This tarp, no. Looked like that. I don't know what it was. He had it bundled up. Well, lo and behold, when we find out this information, and they try to make a big deal about it, I think it makes it more pure. She's at a traffic stop or an accident or something, still a police officer. I forgot about this. You can't make it up. So they get a search warrant, and they go search. And lo and behold, crumbled in the closet is a blue vinyl something where you pull it out, and it's this jacket. You see how evidence of a fact and another
showing
fact
how it
that
builds.
leads to
Right.
fact in question.
Circumstantial evidence and how it
I don't know
builds.
why he put it in there. I don't know why he killed his wife and son. I don't have to say why. I think he did it to protect the one he loved the most. The one he really loved the most.
Why didn't
So
y'all
he could
start
keep
with
his
that in
lifestyle.
opening?
And not be embarrassed financially, and he wanted to keep
That's
going and
the
loving
theme
Alex.
of the case.
I don't know why he kept that jacket. Maybe it was Solicitor Murdaugh's jacket. Certainly consistent. It might have been in that truck. I think one of the family said he kept a lot of stuff in that truck. Might have been out in that something else. I don't know. But he brought it back in there and hid it. 6:30. Days after the killing.
The
And
way
what's inside?
he's walking you through Shelley's
What's on the
testimony
outside?
is very powerful
Just a little bit.
with the story.
Outside here and there. What's on the inside? The inside.
That's why he's doing the rebuttal.
Minimum 38 particles. It got so much that Megan Fletcher finally said, you know, we get, I can't remember the term right now, we get so many, I just stopped. I'd have been there for days. Gunshot residue. Inside the rain jacket, the blue tight garment that Shelley said, I saw him carrying something like that. He got rid of the guns, and he's hiding it there for some reason. Thank goodness he did. Just thank goodness for Shelley for bringing that in.
Thank goodness for Shelley.
That's what he disposed of the guns with. And he went out of town. She said he left, and before that, she thought he'd left, and he came back, and he had moved to ATV, and then he said he was in another truck, and he came back, then he left.
I'm really glad they finally brought this up.
He's disposing and hiding whatever he was doing with that evidence. Only one person knows.
Took it from the smokehouse.
But that blue rain jacket, that tarp, is incredible circumstantial evidence that we ask you to consider when you go back there. Is Shelley making that up? How could she make that up? How could she know there'd be a blue tarp in that closet? Same closet, same stairs, he went upstairs. We went upstairs. I can't explain the tarp on the chair. Don't have to. We can't answer every question. That doesn't mean it's not reasonable doubt. She saw a blue tarp light. It was in that closet, and it's got gunshot residue on it a few days after. Maggie and Paul were brutally murdered. And that's consistent with every reasonable hypothesis. And you know the thing he told Shelley?
I hope they do Blanca next.
The night when they were talking. You're getting married, aren't you?
Yep.
You remember her saying that? You getting married? If you need any money or help with it, let me know. It's incredible timing. Oh, and your job, don't you work in school? You know, I got friends down there.
Yep.
Your man, if you need. I was there 35, 40 minutes, wasn't I? Can you make up the sequence of facts that lead to the conclusion he's trying to get her to say, I was there longer. I wasn't outside longer. Blanca.
Oh, Blanca. These were their best witnesses. I'm not surprised they left them for rebuttal.
Blanca loved Maggie. I didn't realize that really until I talked to her just a few times. I met her years ago at a federal prison. Remember when I saw her? Remember her name. But you know, even when Blanca was quit working for him for a while, and you remember she had health problems and said she saw Maggie on the road somewhere. And they kind of pulled off and just talked. Just called up. Blanca cared about Maggie.
She did.
You knew her so well, she knew what you wore to bed and what you didn't wear to bed. And that kind of bothered her about the clothes that were laid out. Some undergarments, which she knew she didn't wear. But Blanca's texting
Saved it for rebuttal.
Maggie's texting Blanca on June 7th. And in one of his statements, and I'm going to get to those, he said, you know, Maggie wanted to come. She wanted to come. Well, no, sir. No, she didn't. She was having worked on her other stuff. He tries to say in here today, look, she was in Charleston. She was going back to other stuff. Remember the text to Blanca, well, I left the workers there, but I guess it'll be okay. He had said, come. I want you to come. She didn't want to come. We also know that from her sister Mary, who had a little regret in here today. We didn't hear much regret from over there, but you know who regretted? Who was real? Was Mary. I encouraged her to go.
Yeah.
She didn't want to go.
Heartbreaking.
They got in club. You know, it's like siblings. Jane, Marshall, James. I had to get my siblings on the record. We love each other.
Her testimony.
But she had that relationship. You know, we weren't close. When we got
Heartbreaking.
closer as the kids got older. No, we were close. We talked. One of her best friends. And she told her, why don't you go on over there? She regretted that.
Chad, I see you.
But she killed her about it. But that refutes his lie. Oh, she wanted to come. She wanted to come. No, sir, you wanted to come. Why? Had he already planned it out? Was his world collapsing? He didn't have to. We don't have to prove he did. But he got her there. She wasn't planning on being there. Blanca's got the food ready.
Wait, why are we buttoning?
She leaves.
Matters, what are we doing?
Stay on the real train for a minute. She goes home. She gets a call sometime that night. And this is real. What does she do when she hears? She drops the phone. Remember that?
Yep.
Her husband had to get on the phone. She dropped the phone, real emotion, because she cared about Maggie. That's real. And you remember she described that day when she left Alex leaving, and I put his shirt up, got his collar, helped him with his, I assume it was a blue jacket, I don't know. Described the shirt. Remember, just kind of tucked it in. And now on Alex's second interview, when he's confronted by David Owens. And they actually showed him the video of the tree. They showed him that. When did you change? When I saw you that night, you were wearing shorts. When did you change? And you remember what Alex said on that interview? When is that? You sure that? When is that time? Was that? And then he told him the time, 7:44, whatever it was. He said, well, I guess they changed after that. Well, those are the clothes he was wearing when he murdered Maggie and Paul.
It's the first time they've argued that.
Those are the clothes. And what does Blanca tell us? That was on August 11th. She said sometime mid-August. I didn't even know this. I got it. You can't make it up. Sometime mid-August, he comes to see her. Do you remember that shirt when I left that day? I said, no. I mean, yes. It's a Vinnie Vine shirt. You weren't wearing a Vinnie Vine shirt. I fixed your collar. He tries to get her to tell what he was wearing. He tried to say, no, you weren't wearing that shirt. That Columbia shirt, you got one of those. But guess what? I ain't seen that one since. I have not. Blanca and Shelley. That's great circumstantial evidence. Did you ever see that shirt again? Never saw that shirt.
Y'all, I don't know why some of you are saying this isn't rebuttal. This is rebuttal.
Ever.
We're actually in rebuttal, and it actually
You know
is
what?
a
I
rebuttal.
forgot about Shelley. I don't think this was mentioned.
He's rebutting
When Shelley
the defense saying that these witnesses didn't remember.
What she said about his clothes?
And he's going through what they
Shorts,
remembered.
Shirt. What she said about the shoes? Sperry type. Cloth shoe. You remember that?
This is exactly a rebuttal.
When Dave Owens and those get there, and when I think I accidentally put some of the dust out on the... Those weren't Sperry shoes. He's changed his shoes again. I'll get to you in a minute why that's important. From the one to visit his mom, he's got Sperry type shoes. He comes back and puts on the tennis shoes. Why? Is she making that up? Blanca said, I've never seen the shoes before. When I got there the next morning, there was a t-shirt that looked like it had been pulled down, fell on the floor. Where does he keep it? She washes her clothes. Those are clean shorts up there. This is where he kept his shorts. Did he wear these shorts much? No, he didn't wear them much, but she knows that family. She knows where the shorts are, where the shoes are. Do you remember the Sperry shoes? Yeah. Did you see those? Never saw them again. Never saw that shirt again that he was wearing in the video. Never saw it again. And when he confronted her at the house about what he was wearing, she had real feelings and told y'all about that and told law enforcement about that. Is that real?
That's why,
Why is that important?
That's why he mentioned the Velveteen Rabbit, to keep
Because
coming
it
back
goes
to
back to credibility and common
what's
sense.
real in this case.
Those were clean clothes.
What's
that Shelley
concrete?
had washed. Excuse me, that Blanca had washed. And when we get there on the scene that night,
Yep, I like this pacing much
remember
better.
Laura?
Settled in storytelling.
She's sitting in the back. David's in the front. Alex in the front. His lawyer's on the side. And you know, it's something else I don't understand.
He lied about them 40
Your
minutes
wife
though.
and your son have just been killed, and you're worried about having a lawyer around. Everybody said, well, you know, just sled agents. We need to have a lawyer around. Really? My wife and son have just been butchered, and I'm worried about having a lawyer. But they did.
Well, they're his friends.
And that threatening, overbearing, cheating, manipulating. You know what I asked old Dave? Put his hand on his shoulder. So did Laura. What are you doing? I got a heart. Is that rushing to judgment? I got a heart.
They never said rush to
They didn't
judgment.
rush to judgment. They were saying, tell me what happened.
They didn't say rush to judgment much in the closing.
Well, and he starts looking at his phone. You can check my phone, the alibis that he's created, that he's doing. And he says, I went and ran. I got on my knees over here. Went and ran, and I tried to take the pulse of Paul. I'd still be on the ground arguing myself. And I tried to turn him over. I kept trying to check his pulse. Really? I went to Maggie.
He said he had blood
Checked
on
her
his
pulse.
fingertips. Are they going to bring that up
And you
at all?
can't do that in 20 seconds. He's now trying to say you can. You can't. And they've tried to change that. And he never did it. Because what did she say? What did Miss Rutland say? He was clean. He was clean. He was clean. He was clean. He washed up.
He said when he
Yeah, and you
testified he
hear
had
the
blood on his
water running in the
fingers.
dog video. You hear it.
He's not washing up
He
then, though,
washed up.
Metters.
And this phone, tried to make a big deal about this phone.
Oh,
that
because your
you
witness
saw-
was ridiculous.
You do see right afterwards, when we know he was down there, there's some movement on Maggie's phone. But every expert has said, just because if one phone's down here and the other one's walking, you're not going to have steps on that phone. He took Maggie's phone, the golf cart, however he got, drove back up to get those shorts and that shirt. And yes, you can get it and manipulate it and call to see if you made a call, put it down. That's not going to record
Oh, there's a
steps
small
on that
little
phone because it's not moving.
microphone
But
right
that
by the
doesn't
jury
mean
box.
it wasn't with his phone. Don't fall for that. That's not real. Every expert said that. Every expert said that.
He's
And
giving-
doesn't that make sense?
He's giving the jury
You
the
can grab
language
it,
to argue
see,
his
make a
side.
call, put it down. You keep walking, it's not going to record.
That's
If
not
it's
real.
there, it's in the car, it's in the Suburban, and I'm getting to that. So
You
what
get
happened?
one or two jurors on your side with that's not real. They're going to argue it to the other jurors. Look, no, that's
And
not
this is why I
real.
asked Miss Rutland.
It gives them the
And they're
language.
bringing in drug use. If he did as many pills as he said, he'd be dead. You can't
Hence the
take that many
Velveteen Rabbit.
pills. That's your common sense. But why I ask her this, I'm asking, I want to look at every one of y'all. Tell me what he was like in that car. You've got the video. Did he appear to understand you? Yes, sir. Were his answers timely? Yes, sir. Were they subject matter appropriate? Yes. Do you understand him? He can understand you. Look, he's thinking. He's opening the door.
The changing of pacing keeps the jury
Of course he
engaged with
was.
the
And why is
story.
that so important?
It's keeping you all more engaged. It's keeping me more engaged.
He says he didn't go down there. Is that
Pacing.
enough? Yes. With everything
Local
else,
changes.
that's enough. I never went down there. He's in his right mind. I never went down there, Dave. I never went down there, Laura. I never went down there after supper. I stayed up. I took a nap. He goes from taking a nap from 6-7, then next time they met, 6-10, I took a nap. August 15th, you sure you're down there? Or up there taking, yeah, I took a nap. I never went down there. Never, ever, ever. You think he would have taken the stand and said, you know, I was down there, y'all, if that video hadn't come out on that phone?
No, I don't think that at
Well,
all.
no.
I agree with you, Metters.
Now, under Mr. Waters' cross-examination, I lied. Why'd you lie?
That's what everybody's been
I wrote it
thinking.
down. I'm still not.
Would he have told the truth if that video hadn't come out? Nope.
I had paranoid thoughts. Usually I can take a deep breath and get through it. But I couldn't, so I just lied. Once I lied, I continued to lie. And he continued and continued and continued until 627 days later when he took this stand.
Metters, bring it back
The
around.
first time he'd
He
ever
doesn't
told
admit the
anybody.
lie until he's confronted. He doesn't admit the lie until he can't escape
He
it
told his family,
anymore.
he told his friends, he told everybody, and they believed him. I wasn't down there. Why is that so critical? That's the time of death. That's when it happened. That's what the records show. That's when the conversation, yes, it is important. Paul, who used his phone all the time, Paul was in a conversation about the dogs, interacting. Well, send me the picture. He does. And then it stops. Yes, that's when it happened. And then Maggie's phone. A little bit text. She reads that text. I think she went to her car. Y'all decide. Nobody knows. One person knows. She goes to her car. And she's got some rings there she's putting back on. I think she's got 2 rings there, and she's putting on another in the car. Maybe they've been working in the kennels. There's one shooter. There's only one shooter. And she hears that shot, and she comes back around.
I'm not following that point.
She hears the shot. She reads the last text y'all will have in there. I think she opens the thing about Solicitor Murdaugh. He doesn't. And then you don't see anything else. You don't see anything else on the phone. So is that common sense? Yeah, that's when they were gone. Yes. Yes. When they interact so much. Yes. That's common sense. And that's why it's so important. You want to help law enforcement? You're in law enforcement? I was down there. Y'all know what? I was down there. I didn't take that nap as long as I did. Did you hear anything? Why would you not give that information? Okay, then the 10th, with his lawyer, Mr. Griffin, in the car. Did you go down there? No. Look at him. Is he coherent? Is he under the influence of anything? Is he withdrawing? No. I want to help you. I want to help you. And then on the 15th, here's this video. Here's you in the tree. Now, Rogan says he thought he heard you down there earlier. Well, I don't think so.
All the time.
I say it then. Think about it. Well, it's just Rogan's word. Does that make any sense? Just Rogan's word. No, sir, I can handle that. He made a mistake, like Shelley did.
Closing is the best
Mark
part.
it and close.
We all love a good close.
I can handle that, though. But when the video comes out, he's stuck. He's stuck. I'm going to try to wrap up.
Don't make promises you can't keep, Metters. When the video comes out, he's stuck.
Yesterday morning at 2:53 in the morning on the Sweet
And he
Mutt
starts trying to
trial,
protect the
I
person he
woke
loves
up.
most. Alec.
And what he did when he took the stand was corroborated that he's a liar. He corroborated the fact he doesn't tell the truth. The one thing that was more important than anything. And you know, they're putting these law enforcement on trial, talking about blood evidence, talking about other things that were presented to the grand jury, which that blood evidence was investigated, and the state didn't offer it. That's what you do in your prosecution. Didn't try to offer it. Now they're trying to put us on trial for doing our job. Think about that. Blame everybody else. Look, they looked into this, and it didn't turn out to be. So now we're going to blame them. We didn't try to present it. Isn't that ironic? They're now jamming us for doing our job. Jamming us for doing our job. All the evidence of the guns, and I'm going to get that in there. Timeline, the incredible timeline, his lies, all of that, the gunshot residue, all of that's presented. And do we make mistakes? Yes. And that happens in life. But you don't lie and misremember being at the scene of a murder when you said you weren't even there, or being at the scene where your family was brutally murdered. You don't lie about that. That's not a mistake. That's not a mistake. This is the state of South Carolina versus Richard Alexander Murdaugh, not the state versus David Owens, not versus Sled. And I want to tell you something. Sled, Walterboro, Laura Rutland's working with David Owens. Sled starts working with the FBI. They're working together. This is, think about it. Rush to judgment. They gave that man every benefit of the doubt.
Too many, if you ask me.
Oh, what are y'all doing? How's it going? You remember that third interview when he was David Owens said, well,
They didn't even serve a
and I submit to you, they're taking those interviews where he's trying to come find out what they've got on him. Well, how's this thing looking? How's this thing looking? Well, we've got some shell casings. By Maggie's body, out over there where y'all shot in the range, and some shots out there by the side of the house, the shell casings, they all came from the same gun. All cylinders in the same gun. You think if they didn't, they could find an expert to refute that, they would have?
Yep.
And Alex says, oh really? So the gun was there? Yeah. You see his reaction? They all came from the same gun on Maggie. Now the other one, Mr. Griffin tried to argue, Paul Greer, yeah, it could have come from that shotgun. Don't know. Is that credible evidence? But it could have. Not saying it did or didn't, but it certainly could have. He's got that gun. Got Maggie's blood on it.
Certainly could have.
Don't know
It's
if
not
he used that or not.
helpful.
But I know the assault rifle's missing. And Will Loving comes from a fine family in Columbia, I can tell you that. Says we were down here not in March, it was more like May or April or May.
Everybody in their
We were
family.
shooting his gun on the side of the house and those shell casings. That's where they found them. And lo and behold, the shell casings match the shell casings around Maggie. They were all cylinder in the same gun. They came out of the same gun. They've been in the same gun. Yes, Mr. Waters is right. That's a family-owned gun.
The missing
And
family
is that
gun.
incredible, circumstantial, and direct evidence? Yes, ma'am. Yes, sir.
No, it's circumstantial. Well, I mean, I guess he's arguing the
can feel
bullets
it
are
like they're around.
direct. The casings are
The
direct.
murderers come in, there'll be a gun there. We'll just use their gun. Does that make any sense? Y'all too young. You ever watch Columbo? When I first looked at this.
He said,
case,
y'all are
this is
young.
about
Did
the
you ever
show
watch Columbo? No, he just
Except
said
this
they're
is
young.
real. And you get to see one of my heroes, the detective, didn't always look that good, wasn't all that, but you got to see the crime, and then you got to see him figure it out.
We've
The
gotten to
mistakes they
Columbo.
made, and that's what happened here.
Bingo.
He killed him. He thought he could get a timeline, but it got him. Within 20 seconds, he's texting Maggie when that phone, when he's passing the location of her phone. Is it common sense? He threw that phone out, called her, and threw it. Threw it, and the orientation didn't go on. They said if you pick it up, yes. And we had somebody come in here, you throw it rough, and it doesn't come on. And what are the chances it's anything else? He'd almost had to bump into him. Almost had to bump into him. And you take this new story, I was down there till 8:50, whatever, go and take a quick nap, come back, he didn't hear the shots, just happens to come back. And common sense, don't leave it with you. Take it back there with you. I'm down there now, my wife told me this. I'm down there under this new story, and the deal was to come talk, go see my mama at 9:30, and you're right down there, you've just seen them now. Well, you said before you hadn't even seen them, don't forget that. And you go up to the house, why don't you say, hey, Mags, I'm gonna go see Mom real quick. It's just a few minutes later. No. You go up there, you take a quick nap, you know what, I'm gonna try to call them, let them know I'm going down. Does that make any sense? And then when you get to the line, you'll see the light. When y'all went out there yesterday, those trees are much lower. Go back in and look at the way it was. And I think even Buster said when you get down there, if the light's on, you can see. Why don't you just go right over there? Hey, I ain't going down there. No? Doesn't hear anything, doesn't do anything, he just takes off. He just takes off. Does that make any sense? We've proved that nobody else could. With that timeline. Does it matter when he's rushing back? Yeah. I doubt he's ever killed two people before. So he's not thinking, he's frantic. Puts the wrong two shells in the gun. Coming back, he's got Maggie's phone. It had been sitting there, that's why the steps weren't on there. He's moving. He gets it. I can't take this phone with me. He's a lawyer, so he tosses it out. That's the only thing that makes sense. And what did he say about Paul's phone when he went up there? You know, I started to get, I didn't know I got it. And then it kind of just popped out too. Does that make any sense? You got to evaluate everything. You can't believe somebody's credible one thing.
Slow that
How can
down.
you believe them on the
Whoa.
ultimate issue when they say
Slow
they're
that
guilty?
down.
Well, the only thing they corroborated for you throughout the investigation, throughout this trial, and throughout Mr. Waters' cross-examination is he's a liar. And that's all you can judge people on. the three witnesses that were beautiful, that were uncontroverted.
Blanca.
And one was Paul. He didn't testify to you up on the stand, but he testified to Dr. Raymer, and he testified to his son. And here's so beautiful of evidence. It's so pure. He didn't know he took that video. That's why he said he wasn't down there. And this is beyond all that. We respectfully submit. Paul knew. Dad, I got some insurance. I got some insurance. Not the kind of insurance you've made money off of. An insurance, some clients you gave back and some you didn't. I've got some insurance on you. I don't know why you killed me. I made some mistakes. You heard a lot of good things about Paul too. I know I put your life, open your life, your fake life with this boat case. Your finances are coming out. I know that. But if you go lie and say you weren't down here, I got you. I don't know when it'll come out. Maybe you'll go ahead and lie. But this is going to come out. Paul had that insurance on him. And maybe that's why he was worried about that phone. And you can't make that up. Because you remember when I asked David Owens, does anybody else in the world know that that video was out there except Paul? No, sir. And that's incredible evidence. And it did sit there until law enforcement working together, the states, the local, SLED, everybody, got it out. And that's great law enforcement.
April
Thank you.
of 2022.
Yes, and that's when the case changed, along with all the other. Maggie testified to you. He shot me here. He shot me here. And look at all the shell casings around me. Y'all look at them. They're the same ones that Will Loving shot with Paul. They're the same ones that have been shot down there. Yeah. They came out of the same gun. That's great direct and circumstance. And finally, and my
Alec?
daughter-in-law, Sally, and my Aunt Cissy still calls my dad Jack this.
What?
My daughter-in-law been married about 3 months, one of the happiest days of my life, because they were happy. They were watching that kennel video. She and her dog Tater. And when Bubba started to bark, that's what my aunt calls him, Dad, Bubba. Tater bark. And Sally said, isn't it something?
What?
It's your best witness in here of the dog. You know, some people say they got a sixth sense. You think Bubba knew? You think Bubba knew something? You got Alex to say something. Bubba!
Betters!
Thank God for Bubba. DNA, and that DNA, when people live together, you'll have it all over your shirt. That's not it. The DNA in this case, that dog negates all. Thank you, Bubba. And guess where Bubba is now? Bubba's with Blanca. Bubba's with Blanca. You can't make that up. And that puts him down there. And that's the lie he told and told and told. I wasn't down there. Why aren't y'all doing something, law enforcement? Why aren't you telling us you were down there?
That last bit was
Why aren't
well
you telling
outside the
us you were
scope
there?
of rebuttal, but no one objected. So here we are getting yelled at about Bubba. Bubba's name has been cleared. He stopped short of saying Bubba's a good boy. I don't know why the audio cut out. I don't know if there was an objection, but the audio in court just cut. I don't know why. Oh, because Creighton has something to say. What? I have never seen an attorney stop and consult with another attorney in the middle of
If he
closing.
tried to respond to the phone, as Mr. Griffin said, it would show that he was going to Malmina. He had to get rid of that phone. He had to get rid of it there. Finally, it's about your greatest power. My dad gave it to me when I was young.
What?
He said, read it.
Back to the
Your
Velveteen
greatest
Rabbit?
power. You know what it is? Your greatest power is your power to choose. Choice. We've all got it. We're born with it. We use it every day. We use it when we treat people, whether we say hey, whether we're nice, whether we forgive people. We make good decisions, we make bad decisions. But what my dad always told me, don't blame anybody else. If you make a good choice, that's good. Don't get too cocky, be humble, but that's good. But if you make a bad choice, you're responsible for it. There are consequences. It's your greatest power. And for whatever was going on in his mind, his world's collapsing. It's coming down. All these world is coming down financially. He's confronted that day by somebody's law firm. Where's this check? He's got another hearing coming up. It's a motive. Don't have to have it. But yeah, it's there. And is this rational? When he said that, is that rational?
So close to the
Was it
jurors.
rational to be on the side of the road and claim you're shot? And when you're in the ambulance,
Murdering's not really
now
rational.
watch this if you need to, and you're talking to the officer in the ambulance, and you say, what happened? Oh, by the way, he wanted to kill himself. He called 911. He called 911. When he told the officer in the ambulance, well, what happened? Well, some guy shot me. He even did a sketch. He faked the sketch. But what did he tell the guy in the ambulance? It sounded like a shot. He's trying his world, and he says there in that last interview with the call-in interview, Mr. Harpootney and Mr. Griffin, what you got in there. Ryan, I'm sorry, I lied about everything. I was under a lot of pressure, had a lot going on. Really? Your wife and your son were murdered 3 months ago, and now this is the real Alex. Well, my world's coming down. My world, Alex's world is coming down. Been confronted by his law partners.
I'm sorry.
Losing
to
his
everyone
job.
with
That's
headphones.
me. My world's being affected. Not
Apologies.
about that, but now, and I'm sorry I lied. I've lied about everything. Richard Alexander Murdaugh loved, I think he loved me. I think he loved Paul. But you know who he loved more than that? You know who he loved more than that? And who he's going to make sure that life, wanted to make sure that life, he loved Alex. And he exercised his greatest power of choice to make sure that life continued, or try. And it couldn't. And now, ladies and gentlemen, after his honor charges you, you're going to go back there and exercise your greatest power. Based on the evidence you've heard, the evidence you haven't heard, the credibility, the believability of the witnesses, and especially of Richard Alexander Murdaugh, who has lied and lied and lied and lied, and it's been okay. And he got you through. It stops here. We respectfully request it stops here today. No, it's not okay. And we're going to exercise our greatest power and find you guilty of killing Maggie and Paul. Thank you.
And like that, Metters is done. The judge is going to break for lunch, charge the jury after lunch, and they'll get
Ladies
deliberating
and gentlemen,
today.
you've now heard the evidence and you have heard the closing arguments. Next up will be jury charge and then your deliberations.
They're going to charge them after
We're
lunch.
at lunchtime. We're going to take a break for 1 hour and 15 minutes for lunch, and you'll come back. I'll charge you on the law, then you will deliberate. Please do not discuss the case.
Help, 1 hour and 15 minutes. It is 1:40 in the East. What time are we back, chat? Thank you. My brain has stopped after Metters has destroyed, beyond a reasonable doubt, my eardrums. It is uncontroverted that my eardrums have not survived that rebuttal. We're going to talk about Metters' rebuttal in a minute. The AG of the state sitting next to Creighton Waters. The jury's being excused. Everyone else is standing as the jury's being excused. 2:55, thank you. 2:55
When
Eastern.
we resume, I intend to go directly into charging the jury. When I'm charging the jury, no one comes, no one leaves.
Yep.
Before we break for lunch, are there any matters to discuss regarding the jury charge?
I think the state emailed a revised charge on the the other pending charges, which we did not have any objection to. I don't know if Your Honor.
We received it and incorporated that into the charge with correcting a typo here, typo there. Any,
We don't have any additional charges or any objections.
And without addition, we don't have any either.
all right, we'll be in recess for an hour and 15 minutes.
Okay.
All rise.
We're in recess. Uncontroverted that it's time for lunch. Yes, there's a reason we've called Metters the My Cousin Vinny attorney. Was it effective for the jury or not is going to be different. I know there's some discourse in the chat, but after Jim Griffin's closing, Metters' closing, well, Metters' rebuttal, though there were times it slipped into closing, Metters' rebuttal was a breath of fresh air. We saw some passion, storytelling, change of cadence, change of volume. But what I liked best about Metters is the way that he used the witness's testimony to tell the story to the jury. We didn't see a lot of that in the other closings in this case. We saw a PowerPoint with clip art that I hated. We saw a kind of more, kind of a closing from Jim Griffin. But what we saw from Metters was, this is what Miss Shelley saw. This is what she told you. This is what you heard. I still need to run it back and see if he snatched water off the jury bench, the bar there, because I think he did. He was banging on the bar. But he definitely had more passion than anyone else's closing. There were times that Creighton did, but it's a much different style than Metters. I like the way he wove in the story that the witnesses told. And at the end, he wove in the story from Paul and Maggie. Was that powerful to you? Told you what Paul did. He stopped short of saying, Paul is a little detective, and he saved the evidence that is the key to this case on his phone, and no one knew it existed until April of 2022. And I like that he brought up the fact, would Alec have gotten up here and said to you he lied to the police about the kennel and being at the kennel if that video didn't exist? And I think in the moment I said, nope, no, he wouldn't. And he wants the jury to hear that in their head too. No, he wouldn't have stopped lying because he wasn't caught until that video. And it took them months to crack Paul's phone. We remember the testimony. We all joked about switching from 4-digit passcodes to like 6 or 9-digit passcodes. So I thought Metters' rebuttal was good. I don't know how loud it would have been to the jury. You could see that there were microphones along the jury box. So it might have been perceived louder to us coming through the microphones than it was in court. It might not. Because there was a point at the beginning of his rebuttal when he was standing in front of the jury box and he said, listen to me. I wonder if there is a juror, or listen to me, please. Not listen to me. Listen to me, please. I wonder if there was a juror who was not either making eye contact with him or who he did not think was dialed into him, because he was standing at that end of the jury box closer to the doorway through a lot of his closing when he wasn't pacing, looking at one juror. And you could tell he was looking at somebody. He's not trying to grab the jurors that are on his side. He's trying to grab the jurors who might not be on his side. And then he's trying to give the jurors the language that they need to go back into the jury room and make an argument for him. And that's where the Velveteen Rabbit came in with, is this real? It assumes that everybody's read the Velveteen Rabbit and remembers it. But that's where it brings it around with, is this real? Is the cell phone real? Is the timing real? Is the lie real? So trying to tie it back to what's real. Blanca's real, he said. Shelley's real. You heard their testimony. You heard how Alec made them feel. Like they had to change their story. And he tied it back around, but why would they need to change their story? Why does the timing matter? Because he knows that's the time of death. Why does lying about the kennel video matter? Because he knows that's the time of death. And that was his rebuttal. And that is the last thing that the jury will hear from anyone except the judge. The judge will give them the charge and then they will go deliberate. I don't expect this jury to come back today, y'all. I don't. But we're going to be here for a while chatting after lunch once the jury is charged, just to see if they come back with any questions. And if you want to make sure you stay in the loop, look, you've got to follow me on either social or sign up for the Law Nerd Alert or all or both or what have you. I will update while we are on Jury Watch. Let's just talk about Jury Watch real quick. What's going to happen on Jury Watch? Let's just chat about that real quick. Hold on. Where'd my swoop-a-doop go? I lost it. We are going to be on Verdict Watch. I will keep you in the loop when I'm going to go live. I will put up the live stream as far in advance as I can. We don't know yet how the judge will read it. We will hear after the jury goes back to deliberate how long the judge will give the attorneys. They will need to stay in the area. We know that questions will be read in open court and responded to. If I am going to go live over the days that we have for Jury Watch, I will email you at Law Nerd Alert. I will text those of you in North America on the text crew. I will post it up on Patreon. Whether or not you are a paying member there or you just follow me there, I will post it. All of those posts will be public so you can see. I will post it on Twitter. I will post it on Instagram. I always forget Instagram, but I will post it on Instagram. We will post everywhere. And then, of course, I will put it in the community tab and here on YouTube. YouTube alerts are not consistent and reliable for me. They're just not. So it will go all the places. So if you want to be on the text crew, you need to be in North America. TextEmily.com will get you there. Do it from your phone and it'll take you right there to sign up. TextEmily.com. Law Nerd Alert is an email-based alert. It will get you there. It comes from @EmilyDBaker.com. Just go ahead and make sure that you've whitelisted the email so you'll see it and it doesn't go to promotion so you're ready. All right. Madeline Warner in the chat said, EDB, what are your thoughts on Jim and Alec not sitting next to each other after Jim was done with closing? I don't know. I didn't know if it's because he wanted to be able to hear matters better to object if needed, or if he wanted to be able to see the jury better. So I'm not trying to read too much into it because there's a lot of reasons that it could be. And seeing the jury is one of them. So the last poll we did was, did you like Meddar's rebuttal? 76% yes, 24% no. I'm going to go to, I'm going to end this poll and I'm going to ask, Miguelina, can we ask whose argument did you like better? Waters, Medders, no, Waters, Griffin, or Medders? And let's ask those three because I only pulled the first two. Let's see who you liked best of the three. I'm going to get to some of our, we have a lot of super chats. I'm going to do as many as I can and then take a lunch break because I am hungry. I will be back in just about an hour after lunch. I am not going to take a poll on guilt, not guilt, because I don't. So I'm putting up a poll on which of the attorneys' arguments you liked best. The Great Big Geek said, I've gone nuts looking for the mischief brief and I can only find the give 'em coloring pencils. I haven't had a chance yet, but I will put up the mischief brief publicly. I'm going to pull out the coloring or the connect the dots pages and coloring pages. So I'm going to pull that out and put it up so we can all do the connect the dots while we are waiting for a verdict. That's something I'll do at the end of the day today, and I'll put it up and share it all the same places. We'll email it out. We'll share it all the places. You will get substantially less emails once we're done with this case. It will be a Monday, this is what's going on this week, and a Friday, this is the links to everything that happened this week. That's what you will normally get. While we are in trial, you will get more just to keep you in the loop. Christy Richardson, I think we can guess which way the juror was leaning by Poot's response. The juror probably said what they expressed, and I think we can assume it. News Nation say an alternate juror fell asleep yesterday. It seems that has been widely reported. Elizabeth said, Emily, this is witness tampering by SLED. I hold SLED in contempt, and so would you. Appeal much? What other jurors have been approached by SLED? No, Elizabeth, it's not witness tampering by SLED. SLED was investigating the fact that the juror spoke to others outside of this case because that had already been brought to the court's attention by email. This was not SLED going rogue and talking to jurors. They were investigating the jurors' improper behavior. So no, I don't think it's witness tampering by SLED. First, not a witness, it's a juror. I don't think it's jury tampering by SLED. They were asked to investigate because the juror was talking to others. They talked to the juror and they talked to the other. No, SLED talked to the others. Who the email came from, I don't know. The email came from a third party. So with that, all right, let's continue on. I did not have a dozen eggs on my bingo card today. Today we have eggs and we've got chickens and we've got Bubba and we've got all the rest of it. So SLED's investigating what went on with the juror. And I see you guys talking about it in the chat. That's why I'm addressing it again. SLED's investigating what happened with the juror, is investigating something that was already brought to the court's attention. It was not them initiating that investigation. It had already been brought to the court's attention. That's everything I gleaned from this morning. And if you want to go rewatch, it's at the very beginning of the day today. Go rewatch it. There are tons of stations that don't have me talking over it. I didn't talk too much this morning because I wanted to hear what was going on, but there's that. Oh, Columbo was on the thing. The court addressed an ex, like the juror's ex, but didn't really make it super clear and said it had nothing to do with that. So yeah, T-Mac, does AM stay in jail until the verdict is returned, or does he go to the courthouse every single day? It depends on how far apart they are, and it depends on the time that the court gives. If the court says, look, I want the attorneys back here within 10 minutes, he will stay in the courthouse. The courthouse has holding cells. He will stay in the courthouse. If they say, look, when the verdict comes in, we will give it an hour for media, for juror or lawyers or whatever, and that's within it, then they'll bring Alec in. It just depends. It really depends on their policies and procedures. Emily, I were a juror. If I were a juror, my mind wouldn't have been made up before closing arguments. Do you think most jurors parse info without needing it broken down? It depends. Some jurors, I think in a case like this, it's hard to make up your mind. I think jurors have a way that they're leaning before closing, but I think closing is powerful to the jurors. Some jurors are going to have their minds made up. They're told not to, but some jurors are going to have their minds made up. But I think in this case, it's hard to make your mind up before closing because it's 6 weeks. They have no notepads and there is so much information, and it was not presented clearly by the prosecution until, well, it started getting more clear at the end with the timeline, but it was not presented super clear. So, Casey Hawley said, Emily, can the jury request and receive a copy of the Velveteen Rabbit? No, it's not evidence. And I'm surprised the defense didn't object during Meddar's rebuttal when he started talking about what his daughter-in-law or sister-in-law or someone was saying about the dogs not barking on the video. But then when they were watching the video at their home, the dogs started barking. I think that went a bit outside of the scope of the rebuttal for me, but they didn't object. So there we are. Sarah Morgan said, I am spending this money to say how much I despise his yelling. Fair enough. It definitely jump scared me once or twice. Emily, I am just thankful you didn't fall out of your chair during that rebuttal. There was a lot of yelling. And I was like, there were times we were like, okay, we're good. We're not yelling. We have a pace. I'm okay with this pacing. And then bam, yelling. Do they bring up how the little detective solved his mother's murder? A little bit. And kind of. Not so succinctly, but kind of. I wish he would stand still. I don't think Meadors is capable of standing still at all. At all. This is longer than 45 minutes. Oh, it sure was. I'm going to get to questions the best that I can. This was from earlier. Find your road. If I'm bored, the jury is bored too. I'm sure at points today, the jury was very bored. Meadors was definitely trying to wake them up. Brooke Hardy said, as a Southerner, the jury won't take too lightly to all the lies. I was always told you don't have to lie if you don't have anything to hide. And that, again, regional beliefs, experiences, commonalities, attitudes are what these lawyers know better than any of the rest of us. This is their location, their jurors, their home. So if lying is going to be a tremendous issue for this jury, I am not surprised that the prosecution leaned in over and over and over. And I've seen that comment multiple times, that is a very common, commonly held belief. And again, the jurors are, or the lawyers are doing what they believe is best in their experience for this jury, the way they will connect to this jury the best. They have watched their faces. They have listened to them. They are from this area. That is their job. So, AG cared about first close because they were wrong too. The AG didn't care about the defense's argument is that the AG didn't care about the first close until the fucking shit show with the white shirt. And then they switched their minds. And I think that was a good argument. I just wonder if it got lost a little bit. They presented the shirt to the grand jury. They presented the initial report to the grand jury. They sure did. And not the confirmatory report. And it seems that they presented the blood spatter guy to the grand jury and not to this jury. Trust me, if Alec is or don't trust me, ask all of the lawyers everywhere. If Alec is convicted, that the grand jury will come up at the appeal, the 404 will come up at the appeal, all of it will come up if he is convicted. Tommy said, I watched Columbo and I'm 5'2". I officially no longer like the prosecution. Am I old or a child assassin? It is a very fair point. It is a very fair point. Grandma said, Emily, how does it work if Alec confesses to his lawyers? Do they have to reveal that? No. Or do they keep it a secret? Yes. I feel like Jim knew something we didn't. Jim knows a lot that we don't. I mean, the prosecution knows a lot that we don't too, but Jim knows a lot that we don't. I worry that for Jim, there is so much of his own personal knowledge in this case because he was around for so many of these events. There were so many personal relationships for him to these attorneys. I just wonder if him holding back his personal knowledge of all of this and his personal feelings of affection for these victims can come across as if he is withholding something more from the jury. And I think I've changed. I don't think Jim should. Here's where I was at before. I'm glad that Jim was taking over the closing arguments from Poot. But I think after watching Jim's closing, it probably should have been their other attorney, Barber. I think Poot had annoyed this jury. I think Barber had a very measured level of snark and indignation with the cell phone throwing expert. He was clear. He was concise. And I really think he could have delivered it without the personal, just all of the personal and internal struggle that we saw Jim Griffin going through. And we saw that internal struggle for Jim Griffin with questioning Alec too. But they might have thought it had to be Jim Griffin. He's the one that questioned Alec. And it might have been Alec saying, you need to get up there and deliver this for me. I'm your friend. And this is why surgeons don't operate on family members. And I think Jim was too close. And I just wonder how much Jim holding things back will resonate. I don't know if he's holding back that he knows what happened that night, but he's holding back everything that he does know about this case because he knows his family well. And you can see it. How the jury reads that depends. But wasn't it interesting in Jim's closing that he stood in the doorway and said what? He shot Paul with the shotgun and was going to put it down and grab the other gun. Saw Paul come out of the doorway and reached it up and shot him again. I'm like, are you watching Law and Lumber's channel? Because that's how he speculated the only way it could have happened is if you look like you're putting the gun down and then you pick it up and shoot again. So Jim Griffin is arguing that whoever the shooter was had both guns sitting there right up against the feed room. And that lines up with all the physical evidence that shows that the feed room, he was coming out of the feed room, dripping those direct blood drops off of his arm, and then was shot as he came through the feed room door by somebody standing at the feed room, and he wouldn't have seen the person standing there. And the jury now knows that better because the jury just went there and saw it. Did Jim Griffin deliver the most clear theory in his closing of how one shooter could have done this? Maybe. Maybe he did. Going to put the gun down, switch guns, sees that Paul's not taken out because it's a 1 in a million shot that Paul is not felled by that first shot. 1 in a million that wasn't a fatal shot, and was going to switch guns. Who would have known that wasn't a 1 in a million shot other than somebody who hunts a lot? Maybe. Going to put the gun down to switch guns, and then sees that he's not dead and is there kneeling down shooting it. And why did Jim Griffin say it didn't have to be somebody who's 5'2" to 5'4"? They had their experts say it couldn't have been someone who's 6'4". And then in closing, Jim's like, could have been somebody kneeling, could have been crouching down. Why are you conceding it, Jim? It's just odd indeed. Odd indeed. All right, we're going to get to some more super chats. Shelly, thank you for the super chat. My Southern grandma always said, if you lie, you will kill, steal. And if you steal, you will kill. So for Southerners who live by that mantra, it's not a stretch that someone who lied as much as he did, stole as much as he did, could also possibly kill. And this is why we have regional juries and attorneys that work in those areas, because they know what the jurors know. They grew up like the jurors, and they know that too. I've seen that a lot throughout this case in the chat. A lot. Question, when you prosecuted with another lawyer and they were arguing inappropriately, did you call them out once they sat down? No, not until you're back in the office. But I never really had, I didn't have a lot of cases that had two prosecutors on them at all, because there's just not the resources for that. But no, we always discussed strategy and we talked to each other about strategy. I would never have second chaired a case with an attorney who I didn't absolutely trust. Wouldn't have it all. Maria Ann said, thank you, Emily. New to your channel. You make it easy. I try to break it down. What the heck is the Velveteen Rabbit reference? I think to the real. It needs to be real. Let's see. This was from earlier. Thank you. That was cleaning up the chat asking about it. I'm going to get to just a few more questions. Bubba for the win. Absolutely. Bubba, I think Bubba got some respect put on his name. He is the goodest boy. Laszlo said, thanks to my friend Lisa for letting me know about you. Do you think the overnight break changed Jim's closing rather than what he already had to go? I don't know. Maybe, but I don't know if that was for the better. Also, with that, what was I going to say about the overnight break? I was going to ask you if the overnight break let you think about, and I'll ask the chat now. I should have asked earlier. And I'm glad you found me, because they keep burying me behind behind court TV, which is fine. We don't take commercial breaks. But did you think about the closing from the prosecution overnight? I mean, I know I did, but I was on Scripps News last night, so I was talking about it still. But did you all find yourself thinking about it overnight? I want to know what you think. Let's see. Daniel Morris said, how can you manipulate evidence Poot states when he lied in court? I don't know how to answer that. Gingy Prob said, I remember when I met her, I remembered her name. Unlike Poot, he did make it very clear that he liked Blanca and remembered Blanca. Apple Noir, this is a very high compliment. My husband calls Emily purple noise. I am here to be your purple background noise. I'm here for it. Sussex Sandra, I missed the last 2 hours. I was driving home from work. Is this chap state rebuttal closing? He's very Southern sounding. I think we're talking about Metters. Metters being our My Cousin Vinny prosecutor, yes, there are times that I found Metters charming. There are times I found Metters annoying as hell. It will depend on how the jury feels. Seesaw said, I think My Cousin Vinny writer used this lawyer to write the prosecutor. I agree with you. I agree with you. Because Metters has been doing homicide trials for 35 years. Metters has done trials with Poot. He was brought in because he's done murder trials with Poot before. And what did he call Dick Harpootlian? The smoke screen machine, which I thought was kind of funny that he was talking about his nickname for Poot. Honey said, what we got was, I wouldn't be up here if I knew he had lied. Giving us a taste in Emily in court would make a good reality show. No, it's easier to do on the internet when you don't have to deal with all the, actually being in court bit. I'm not as tired as these attorneys are. These attorneys are exhausted. It's much easier to sit here from my perspective with just what's presented to this jury and give you 5 minutes of arguments I would have liked to see them make. But the amount of decisions that these attorneys have made over the last 6 weeks cannot be understated. The amount of fatigue that goes into a 6-week trial. A 1-week trial is fatiguing. A 2-week trial is fatiguing. Once you get to a month, 6 weeks, the amount of exhaustion that is there is real. You have to find a way to overcome it. So it's way easier for me to sit here and just say, this, in the way that I would want to see it argued. And I'd want to see some of those arguments. But it is very difficult at the end of 6 weeks to summarize how much they've seen. I know the stakes are so high. I wanted them to strip it down for both sides more. I wanted to see the state strip down the arguments to just the most important, and same with the defense. Truly wanted to see that from both sides. And I think they felt that they needed to address more. And they didn't want to leave anything out, because this is the thing that's going to sway this jury. I still think this jury this is the type of case. This is the type of case where you can get a hung jury, because if there are jurors that think that the state is overreaching and they have not proven their case, they are not going to shift their position. And if there's jurors that think that he did this, they're not going to shift their position. This is such a horrific crime. It's very, very hard to compromise. Hogue Law coming in with the perspective. Hold on, where'd it go? My comments just froze in the chat, Hogue, because I wanted to pull it up on the screen. It's definitely been a long time. I was in the ICU when this thing started. So for those of you that are new to the channel, Hogue Law has a great channel here on the YouTubes, but was in the ICU when this trial started and was out taking a walk in the beautiful weather at the park with his family yesterday. But Hogue's also speed running recovery because he's Hogue. But yeah, this trial started in January. It's March. And I get that February is like a little bit short, but it's March. And this jury's not going to get the case until after jury instructions. And with that, I know I have a lot of super chats we didn't get to. Angela asked the question I was thinking. I thought the judge said one person closing. And then Metters did the rebuttal. I don't know. Simply Amanda said, Emily, your mock closing gave me chills. I'm sad that there isn't a place to watch you in the courtroom after that. No, it's good. It's all for the best. By the way, in law school, I was not selected to the mock trial team. I was not one of the popular kids. Weird. It's not weird at all. I've never been one of the popular kids. That's why the law nerds are here. We build our own thing. We create our own table and we get to hang out together with all our other nerd friends. But no, I was not on mock trial in law school because I was not one of the popular kids. But it's funny, isn't it? So it's funny because with my kiddos, when they're just like, oh, I didn't get selected for this, I didn't get selected for that. I'm like, you'll find your way and you'll find your own thing. And it doesn't matter what other people think of you, as long as you are happy with you. And that's what we do here on the internet. It doesn't matter what other people think. We as a community are happy with our community. It's not for everybody. It's true. You'll see them come into the chat occasionally and be like, "Meh, this chat has rules." Yes. It's okay if that's not for you. Bye. So with that, it is time to say goodbye. Goodbye, 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 goodbye. Where are the popular kids with their channels? No, popular kids don't have channels. Popular kids don't start YouTube channels. YouTube channels are for those of us looking for our community. All of us are a little bit the odd ones. And that is what I love about YouTube. You know, when you look at a channel like Mr. Beast and you look at him talking about his YouTube journey, he's like, I was obsessed with this and nobody wanted to talk about it with me, so I did it myself. I'm obsessed with YouTube, so I just built it. Same. I want to talk about law and I want to talk about housewives and I want to talk about pop culture. And the people in my immediate life don't always want to talk about all those things, but y'all do. So here we are talking about it together. You just go find your people. I don't know if the popular kids feel the need to go find their people. Maybe they feel like they found them. Doesn't matter. We're here now. Cheers. Oh, Gloss says popular kids don't start YouTube channels. I feel so seen. Right? Because they think they're look, YouTube is not for those with the biggest ego. I think you got to come in with a humble heart. That's not for everybody. That's for the channels I like. You got to come in with a humble heart and look for your people. That's what this platform's about for me. It's about community. And it's about finding the people that want to talk about the same weird shit you want to talk about. And I don't care what the weird shit is. It might be hosing down driveways. It might be makeup. It might be historical dresses. It might be law. It might be all of those things. It might be, I don't know, memes about Minecraft songs, my kids. But we look for our people that want to talk about the weird shit that we love. So with that, I will be talking about more weird shit that we love after lunch. You all are the best. The last poll. Which of the attorney's arguments did you like the best? With over 12,000 votes, Metters, 55. Creighton, 35. Griffin, 9. I'm going to go see what the internet had to say about that closing while I eat some lunch. Runkle, I saw that you messaged me. I'm going to go check it. And I will see you guys after the lunch break. You are the best. Hold on. I need to go find my outro. We're professionals here. I'll see you in about a half an hour. Bye. You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.